Accused, where is the law that accused should be heard? No, nothing doing. Yes. Hey, no, what? No. In the garb of investigation, if they do, they'll do. All right, Kodi. You serve on whoever is that petitioner tomorrow. Kodi, 10:30 tomorrow. Take that. Watch what connected. Right, give it. We'll see. Madam, ad barli nade. CRP fresh matter. Kodi ಆಯ್ತು. ಒಂದು ನಿಮಿಷ ಪೂರ್ಣಿಮಾ. ಸರ್, ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡೋಂಗಿದ್ರೆ ಮಾಡಿ. ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ. ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ಅದಕ್ಕೆ ಏನ್ ರಿಯಲ್ ಅರ್ಜೆಂಟ್? ಒಂದು ನಿಮಿಷ ಪ್ಲೀಸ್. ಎಸ್, ಸಾರಿ, ಹೆಂಚ್ಮೆನ್ ಆರ್ ಕಮಿಂಗ್. ಓ ಪರವಾಗಿಲ್ಲ, ಮೂದು ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ವಾಟ್ ಟು ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಆಗ್ಬೋದು ತಾನೆ. ಇವತ್ತು 2:30 ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ ಇದ್ರೆ ಕೊಡಿ ಟುಮಾರೋಗೆ. ಒಂದು ನಿಮಿಷ. ಎಲ್ಲರೂ ಹೇಳಿದ್ರೆ ಕೇಸ್ ಆಗುತ್ತೆ. ಡೋಂಟ್ ಡೂ ದಟ್ ಪ್ಲೀಸ್. ಎಸ್, ವಿಲ್ ಗೋ ಲೈನ್ ಬೈ ಲೈನ್. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನೋ ಸರ್. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನೋ ಸರ್. ಎಸ್, ಅರೆ ಹೇಳಿದ್ರೆ ಕವರ್ಡ್ ಮ್ಯಾಟ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಯಾರು ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾರದು ಬಿಡಿ. ಎಸ್, ಇಬ್ರು ಹೇಳ್ಬೇಡಿ. ಎಸ್, ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕಾ ಪ್ಲೀಸ್? ಥ್ಯಾಂಕ್ ಯು. ಗಿವ್ ಇಟ್. ಎಸ್, ಮೂವ್ ಇಟ್ ದೇರ್. $2:30 ತಗೊಳ್ಳಿ. ಹಿಂದೆಯಿಂದ ಹೇಳಿದ್ರೆ ನಾನು ತಗೊಳಲ್ಲ, ಯಾವ ಮೆಮೊನು ತಗೊಳಲ್ಲ. Am I not following something? Please cooperate. Yes. ಅದು ಎಲ್ಲದ್ರಲ್ಲೂ ನಿಮ್ದ್ರಲ್ಲಿ ಹಂಗೇನೆ, ಸುಮ್ಮನೆ ಇರಿ. ಎಸ್, ವೇಟ್ ಸರ್. ಎಸ್, ಯಾವತ್ತಿದೆ? ಯಾವತ್ತು ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್? 27ಕ್ಕ? ಕೊಡಿ. 26ಕ್ಕೆ ಕೊಡಿ. ನೋ 2:30 ಏನಿಲ್ಲ, ಅದು ಕೊಡಿ. ಅದು ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ. ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ. ಆಯ್ತು, ಕೊಡಿ, ತೊಂದ್ರೆ. 2:30 ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಏನಕ್ಕಾಗಿದೆ ಸರ್? ಕರೆಕ್ಟ್. ಕೊಡಿ. ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರು ಒಂದು ತಗೊಳಲ್ಲ. ಯು ಕಾಂಟ್ ವೇಟ್. ಐ ಮೇ ನಾಟ್ ಕಮಿಂಗ್ ದೇರ್. ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಮೂವ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಗೋ ಟು ದ ಅದರ್ ಕೋರ್ಟ್ ಅಂಡ್ ಕಮ್. ಇಫ್ ಸಮ್ ಅದರ್ ಕೋರ್ಟ್ ಇಸ್ ಅರ್ಜೆಂಟ್, ಪ್ಲೀಸ್ ಗೋ. ಎಸ್, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಯಾವುದು ಬರಲ್ಲ ನಾಳೆ. ಮೂವೇ ಮಾಡಬೇಡಿ. ಎಸ್, ವೇಟ್. ಎಸ್, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ ಇದ್ರೆ ಕೊಡಿ. 2:30 ವೈ ಸರ್? ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್. ನೋ 2, ಅದಕ್ಕೇನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಕೊಡಿ. ಲೆಟ್ ಇಟ್ ಕಮ್ ಆನ್ ಫ್ರೈಡೆ. ಯು ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ವೆಕೇಶನ್ ಮೂವ್ ಮಾಡಿ. ವೆಕೇಶನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಹೆರಾಸ್ಮೆಂಟ್ ಎಲ್ಲ ವೆಕೇಶನ್ ಬೆಂಚ್. ಅದು ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ನೋ, ಯು ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್, ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. Oh, thank you. You withdrawal ತಗೊಳ್ಳಿ madam.
Within 2 weeks it was ordered to be release of the goods, my lord. The order is not uploaded.
ಯಾವುದು? ಆಯ್ತು, ವಿಲ್ ಸಿ. ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಾ? Now tell me. Will you please keep quiet?
Yes. My lord, it's a CRP disposed matter for being spoken to tomorrow.
Yes.
My lord, it's a fresh act.
Being spoken to ಏನು ನೋಡಿ. Why?
There is some error in the address of the.
ಆಯ್ತು ಕೊಡಿ. Yes.
My lord, it's a
compilation, my lord.
ಅಯ್ಯೋ ವೇಟ್ ಸರ್, ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇಲ್ವಾ?
Lord, this is the convenience compilation which I had to file.
ಅಯ್ಯೋ ಕೊಡಿ ಸರ್, ಅದೇ ಮೆಮೊ ತರ ಕೊಡ್ತೇನೆ.
My lord.
After vacation.
My lord.
After vacation. Yes. ಯಾಕೆ ಆ ಬೆಂಚಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು 2 ದಿನ? What is this? Yes. ಪರವಾಗಿಲ್ಲ. ಏನಾಗ್ಬಿಡುತ್ತೆ? ಏನಾಗ್ಬಿಡುತ್ತೆ? ಏನ್ ಎಕ್ಸ್ಚೇಂಜ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ಗೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. ಏನಾಗುತ್ತೆ ತೊಂದ್ರೆ ಹೇಳಿ? ಏನ್ ತೊಂದ್ರೆ ಆಗುತ್ತೆ? ಯಾರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ? ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ ಕೊಡಿ. ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್ ಸರ್. ನೋ ಸರ್. ಎಸ್. ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. Move the vacation bench. Move the vacation bench. Yes. Move the vacation bench. 12 judgment ge kodi 2:30. 1 minute. 1 minute. Huh? Early disposa. Move the vacation bench. Sorry. Move the vacation bench. Move ನಾಳೆ ಬಂದು ತಗೊಂಡು ಹೋಗ್ಬಿಡಲ್ಲ ಸರ್ ಸ್ಕೂಲ್ನ. Move the vacation bench. Move the vacation bench sir. Yes. When was it frozen sir? Move the vacation bench. Move the vacation bench. Yes. Who knows what is that? Pending ಆದ್ರೆ ಬರಲ್ಲ. Yes.
My lord.
Yes. Now wait.
Fresh matter.
Wait sir. ಮತ್ತೆ ಬರ್ತೀನಿ. Wait. If it's fresh matter, give it. We'll see how much is pending. No, don't move. No, don't move at all. Pending matter. Pending matter, don't move. Yes. Don't move, sir. Move the vacation bench. No, unless there is pressing urgency, nothing. Yes. Move the vacation bench or immediately after vacation we'll take it. No problem. That's not a ground, madam. In 2 ದಿನ ಇದೆ ಬಿಡಿ. Yes. For what? Vacating stay. ಏನ್ ಬೇಕೀಗ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಬರೋಲ್ಲ. ನೆಕ್ಸ್ಟ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್? ನೆಕ್ಸ್ಟ್. ಕೊಡಿ. being spoken to, what is ಕೊಡಿ? Yes. Wait. Yes. What is FAOJO? Faceless. No, move the vacation. Unless it is faceless, don't move. Yes. No problems. After vacation. Yes.
In 2018, my lord, this honorable court had directed the trial court to dispose of the suit within 3 months. It has not been done.
Oh, very good, sir. After vacation. Yes. No. Nothing. Yes. Next. No. Don't take that memo. Yes. No, sir. Nothing. Yes. What urgency? Tax matter? ಏನ್ urgency? ಯಾವ ಬಹಳ ಹಿಂದೆ ಆಗಿರುತ್ತೆ ಬಿಡಿ.
Blood. In one matter.
Anyway, we'll see tomorrow. Give it. Yes.
Not in one matter, please, Lord. ಇದರಲ್ಲಿ addendum is rejected. Layout ಅಲ್ಲಿ ಈ ತರ.
Move the vacation bench.
ಅಲ್ಲ Lord, what has happened?
Move the vacation bench.
The layout ಅಲ್ಲಿ
Move the vacation bench.
Case number ಎಲ್ಲ ಬರೆದು problem
Nothing.
ಮಾಡ್ತಾರೆ.
Move the vacation bench.
This is the photograph, please, Lord.
Posted for evidence tomorrow.
What?
LAC matter posted for
Lord,
evidence
at least for tomorrow.
How are you concerned about it?
Madam, application is rejected, my lord. They're not permitting me to lead evidence because these documents are with BMRCL. Lord, if I
Move the
don't
vacation
lead
bench.
evidence,
Lord, at least.
they close it.
Move the vacation bench.
Lord, there's evidence in your
Give it. Fresh matter ಕೊಡಿ sir.
Sir,
When impeding is rejected, my property, they are going to compromise tomorrow.
No, sir. Nothing. Move the vacation bench. Move the vacation bench. ಅಂತದೇನಿರಲ್ಲ ಅದರಲ್ಲಿ.
that fresh matter for tomorrow.
ಕಾಂಪ್ರಮೈಸ್ ಇರಲ್ಲ, ಏನು ಇರಲ್ಲ.
execution case, my lord, we have paid the entire amount.
No problem, sir. ಯಾವುದು? ಮಾರ್ಗದರ್ಶಿನ ಮತ್ತೆ?
Fresh matter you can give.
Age about 70 years.
ಅದಲ್ಲ ಸರ್. ಯಾರ್ ಬಿಚ್ ಬ್ಯಾಂಕ್
TV Narasimha Swamy Kids Company.
ಕೊಡಿ.
Delivery warrant has been issued, my lord. Sir.
Lord.
230, my lord.
ಡೆಲಿವರಿ ವಾರೆಂಟ್ 230.
Lord, in this case, Lord.
Fresh matter, my lord, for tomorrow, my lord. Fresh matter
Fresh
for
matter,
tomorrow,
Lord.
Madam 230.
230, my lord.
fresh matter for tomorrow, my lord.
Two matters.
Lord, the fresh matter for tomorrow, please, Lord.
Fresh
Why?
My lord, they have come
ಪೆಂಡಿಂಗ್
up with the fresh matter, my lord.
230 ಕೊಡಿ.
Lord, the fresh matter.
Give it.
230.
Fresh matter for tomorrow, my lord.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಜನರಲ್ ಕೊಟ್ಬಿಡಿ. ಇರೋದೇ ಟುಮಾರೋ. ಗಿವ್ ಇಟ್.
My lords, it's a fresh tax matter. They passed the order without hearing me, without giving me notice. It may be taken up today or tomorrow, my lords.
ಟುಡೇ ಇಲ್ಲ. ಗಿವ್ ಇಟ್.
My lords, they might attach my movables at any time, my lords.
Overnight?
I'm a
Overnight?
I'm a travel agency.
No, overnight.
No, my lords.
Then
No,
give it,
may be
yes.
heard tomorrow, please, my lords.
Fresh matter, my lords.
ವಾರಂಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಅದು 2:30 ತಗೊಳ್ಳಿ. ಎಷ್ಟು ಮೆಮೋ ಕೊಡ್ತಾ ಇದ್ರಿ? ಎಲ್ಲಾರ್ದು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಿಮ್ದು ಒಬ್ಬರದೇ? ಎಲ್ಲಾರ್ದು ಕಲೆಕ್ಟ್ ಮಾಡಿದೀರಾ? ಕೊಡಿ. ಹಾ.
Madam.
Why being spoken? What clarification? Not extended the interim order. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಆಯ್ತು ಆಯ್ತು. ಬೀಂಗ್ಸ್ ನಾಳೆ ಬರುತ್ತೆ. 2:30. Move the vacation bench. Pradeep, move the vacation bench. Vacation bench, yes. Vacation bench, yes. No, yes. Yeah, tomorrow. Yeah, Karana. Sumne fresh matter tomorrow. Move the vacation bench, yes. Paral, move the vacation bench. Move the
ನಾನು ತಗೊಳ್ಳಿಲ್ಲ.
delivery warrant kodi. Move the vacation bench, yes. Huh? Sorry? ಆಯ್ತು ಕೊಡಿ. ಈಗ ನಾಳೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಿಸ್ಲಾ? ಅಯ್ಯೋ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಬೇಡಿ ಮೇಡಮ್. ಡೋಂಟ್ ಮೂವ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್. ನೋ ಮೇಡಮ್, ಡೋಂಟ್ ಮೂವ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ ದಿಸ್ ಸಿಂಪತಿ ಹಿಯರ್. ಡೋಂಟ್ ಮೂವ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ನೋಡೋಣ ಕೊಡಿ. Solve it. We'll see. Events are not going to fall. Events are not going to fall. Don't worry. Yes. ಕೊಡಿ ಸರ್ ಎಲ್ಲ.
2:30, my lord.
We'll see tomorrow ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಂಡ ಕೊಡಿ.
2:30 arrest warrant.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಯಾವುದು?
Arrest warrant issue.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಯಾರ್ದು?
ಇದ್ರಲ್ಲಿ ನಾನು
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಯಾವ್ದಿದೆ ಕೊಡಿ.
ನಾನು ಎರಡು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ.
ಹಾ.
2:30.
ಅದು ಆಗ್ಲಿ ಬಿಡಿ ಜಡ್ಮೆಂಟ್. ಎಸ್. ಚಾಲೆಂಜ್ ಇಟ್. ಎಸ್. Judgmental consideration of interim prayer. Pending matter. Thank you. Yes. After vacation. Yes. Next. $2:30. Withdrawal. Give it. Fresh matters. Kodi sir. General fresh matters. Please give. Yen Rudrappa. 2:30 yake. Move the vacation bench. Yes. Move the vacation bench, Rudrappa. Move the vacation bench. Why? Neighbor has demolished your wall. So what should I do? You want rebuilding of the wall by interim order? Will demolish your house also. 2:30. Wait. Okay. Kottaitala memo. Leave it.
2:30.
Faceless will come with, you don't worry. Yes. Faceless will come. Why? Move the vacation bench. ಸುಮ್ನೆ ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ. ಏನಿರಲ್ಲ. ಪರವಾಗಿಲ್ಲ. 9th phase matter ಕೊಡಿ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
2:30 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ 2:30 ಅರ್ಜೆನ್ಸಿ ಏನಂದ್ರೆ ನೈಟ್ ಎಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಸ್ಟೋನ್ಸ್ ಎಲ್ಲ ಲೇಔಟ್ ಅಲ್ಲಿ ಡಿಸ್ಫಿಗರ್ ಮಾಡ್ಬಿಟ್ಟು ದೇ ಹ್ಯಾವ್ ಡೆಮಾಲಿಶ್ಡ್ ದಿ ಸ್ಟೋನ್ಸ್. ಪ್ಲೀಸ್
File a police complaint.
blood they are not taking any action. Ad interim is
File a
rejected,
GM
blood.
petition.
Blood this is the photograph, please.
ಅದಕ್ಕೆ ನಾನೇನ್ ಮಾಡ್ಲಿ?
blood they restrain blood. Ad interim is rejected in injection blood against the party, please.
Against whom?
Against the plaintiff blood. I am
Give it. Yes.
2:30.
My lords, for 2:30, my lords.
Why?
Faceless, my lords.
Faceless. ಹಾಕ್ಬೋದಾ ಮೇಡಮ್? Faceless. ಬೇಕು ಮೇಡಮ್. ಮತ್ತೇನಾಗತ್ತಾ?
2:30, the urgency this, my lords.
Pending matters don't move. Yes.
They filed a
No problem. Don't move. Move the vacation bench.
petition, my lords, seeking a direction to the Central Board of Direct Taxes.
Fresh or pending?
Fresh matter, my lords, to the last date for filing audit report is 30th September. That's the urgency, my lords. Now, the last date for filing returns for non-compulsory audit was 15th September. 15 days time now, my lords, is given.
Give it. 2:30. Yes.
2:30 matter, my lords.
My lords,
Fresh matter.
The respondents are building the compound.
Fresh matter ಕೊಡಿ.
My lords,
The respondents-
2:30, my lords.
ಯಾಕೆ?
My lords, little urgency. They have been alienated from the property. my
Oh, you
lords.
very good, sir. Move the vacation bench.
My lords,
ನಾಳೆನೂ
for
ಬೇಡ.
tomorrow,
Yes,
my
next.
lords.
No, nothing. Yes.
2:30.
Move the vacation
For
bench.
2:30, my lords, the respondents are building compound wall restraining the entry.
ಬೆಳಿಲಿ ಬಿಡಿ. Let them build. Move the vacation bench. Yes.
Regarding the judgment pronounced on 19th September, my lord.
Huh?
Judgment pronounced on 19 September. There's a typographical error as against.
ಕೊಡಿ.
Tomorrow at 2:30, vacating,
Ah.
vacating interim order.
Vacating interim order
ಅಲ್ಲ,
after
ಅದ್ರಲ್ಲಿ-
vacation.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
After vacation.
4 ಜನ ಪೇಷಂಟ್ ಕ್ಯಾನ್ಸರ್ ಪೇಷಂಟ್ ಇದ್ದಾರೆ, ಬ್ಯಾಂಕ್ ಅವ್ರು ಬೇರೆ ಬರ್ತಾ ಇದ್ದಾರೆ, ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ದೇನೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಟುಮಾರೋ
ಆಯ್ತು, ಅದು ಕೊಡಿ. ಕ್ಯಾನ್ಸರ್ ಪೇಷಂಟ್ಸ್ ನಾಳೆ ತಗೊಳ್ಳಿ. ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್. ಏನ್ ಮಾಡೋದು? ಇವತ್ತಿದ್ಯಾ? ನೆನ್ನೆ ಅದೇನಾಯ್ತು ಮೇಡಮ್? ಸ್ಟಿಲ್ ಹೈಪರ್ ಮಾಡಿ ನೋಡಿ. ನಾಳೆ ವಿಲ್ ಟ್ರೈ, ವಿಲ್ ಸಿ. ನೋ ಟೈಮ್, ವಿಲ್ ಸಿ. ನೀವು ಗೋನ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಫಾರ್ ಅವರ್ಸ್ ಟುಗೆದರ್, ಇದೇ ಆಗೋದು. Unless you see the clock ticking, we will not improve in clearance of pendency. Till the cows come back, we all of you begin to argue. Yes. Move the vacation bench. Move the vacation bench. Move the vacation bench. ಏನ್ ಪರವಾಗಿಲ್ಲ. ಏನ್ ನಾಳೆ ತಗೊಂಡೋಗ್ಬಿಡ್ತಾರೆ ಪ್ರಾಪರ್ಟಿನ. Move the vacation bench. Yes. ಪರವಾಗಿಲ್ಲ. Move the vacation bench. Move the vacation bench. Move the vacation bench. Yes. Where it has to be deposited. ಮಾಡಿಲ್ವ ಇಲ್ಲಿವರೆಗೆ? ಈಗ ಡಬಲ್ ಡೆಪಾಸಿಟ್ ಮಾಡೋಣ ಕೊಡಿ ಇಲ್ಲಿ. I will impose costs on that. If these tricky things are done, we'll see. Yes. Move the vacation. Move after vacation. Yes. After vacation. No problem. Move the vacation bench. Yes. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಅದ್ರಲ್ಲೇ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಲ್ಲ. ಡೋಂಟ್ ವರಿ. Yes. No problem, sir. Nothing is going to happen. Yes. Move the vacation bench. ಕಾರಣ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆವಲ್ಲ.
ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ ಸರ್. ಎಸ್.
ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿ ಮಂಡ್ಯ ಬರಬೇಕಾಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಬಟ್
ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ ಸರ್.
ಬ್ಯಾಂಕ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. ಅರ್ಬನ್
ಮಾಡಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ನೆಕ್ಸ್ಟ್ ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ನೋ ಎಸ್. ಜಡ್ಜ್ಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್ ರೈಟ್ ಅವೇ. ನೋ ಎಸ್. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್. ಎಸ್. No, nothing doing, sir. Yes. No. Yes. Faceless kodi.
Fresh matter for 230 my lords. Trial court had granted interim order restraining the defendant. Despite that, they go and start constructing.
Move the vacation bench. Yes.
My lords,
Construction is not going to complete tomorrow. Yes.
Yesterday,
No problem, madam. Vacation bench.
my lords, yesterday's list, my lords, 2:30, your lordship, after hearing posted specially yesterday for 2:30, my lords. That is, my lords, partition suit, my lords, where the compromise has happened. There is some urgency, my lords. Tomorrow, my lords.
One ತಗೊಂಡ್ರೆ ಎಲ್ಲ ತಗೋಬೇಕು. ಪೆಂಡಿಂಗ್ ಬೇಡ ಮೂವ್ ಮಾಡಬೇಡಿ.
My lord, this is a tax matter being filed on behalf of a temple, my lord. Bank accounts have been attached.
ಪೆಂಡಿಂಗ್.
No, my lord, fresh matter.
ಆದ್ರೆ ಬರುತ್ತೆ.
Lords, can I
Date
make a
may be
mention
assigned,
for?
my lord.
Tomorrow. Yes.
My lord, the first appellate court observes that I am in possession prima facie and then proceeds to dismiss the appeal. And the injunction is as against no one apart from my own vendor, my lord. My own vendor is coming and interfering.
Vacation bench.
Lord, tomorrow, my lord, may I request?
Vacation bench. Yes. Vacation bench. Yes. Next. What? What CRP? So what? ಅದ್ರಲ್ಲೇನು urgency? After vacation. Yes. ಡೆಪಾಸಿಟ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಅದು ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ಹೇಳೋಣ. 2:30 ತಗೊಳ್ಳಿ. No sir. Yes. Move the vacation.
Can I make a request, my lords? Lords, I'm moving a matter for.
ಅರ್ಧ ಗಂಟೆ ಇದರಲ್ಲೇ ಹೋಗಿದೆ.
End of the list, I'm requesting because the order of attachment and the order to furnish security and not to alienate, my lords, stands discharged as against the owners of the property where I am the developer.
ಪೆಂಡಿಂಗ್.
My lords, this is a fresh matter, my lords. Can I request for 2:30? Lords, the reason is the court itself records that they want to sell the entire properties for the purpose of running their business. My entire stakes, my lords, is there in that project.
ಆಯ್ತು ಕೊಡಿ.
Please, my
ಫ್ರೆಶ್
lords.
ಮ್ಯಾಟರ್ ಆದ್ರೆ ಮಾತ್ರ.
Please, great.
2:30.
Fresh matter, BDA has already demoted out of the force.
Fresh matter, my lord. Fresh matter, my lord.
ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಎಷ್ಟು ಬರುತ್ತೆ ಅಷ್ಟು ನೋಡೋಣ.
Ma'am, please.
Seeking for a fresh matter for tomorrow, your lordship.
Why?
The trial court has recorded that the property belongs to me. Now the respondent is entering into sale deeds to sell the
Oh,
property.
move the vacation bench. Yes. Move the vacation bench. Don't give. Yes. Why? Pending. You may lose the property.
because my lord, I was not given an opportunity to lead evidence. Sir. I was not given.
Suit for?
Suit for deconveying property. Therefore, my lord.
Vacation bench move ಮಾಡಿ.
Fresh matter.
Court commissioner appointment at the time of judgment, I will not even entertain. Yes. ಅದು ಕೊಡಿ. Yes. ಬರೀ disposal ಗೆ ಮಾತ್ರ. Yes.
Fresh matter tax either today or
Give it.
tomorrow, my lords. Bank attachment ಆಗ್ತಾ ಇದೆ, my lords. That's all.
ಆಗ್ಲಿ ಬಿಡಿ ಕೊಡಿ.
One matter last year.
After vacation. Yes. Move it after. FR ಇದ್ರೆ ಬರಲ್ಲ, ಕೊಡ್ಲೇಬೇಡಿ.
One matter last reserved for judgment.
ಕೊಡಿ.
Percentage judgments.
Call the case.
May it please, my lord, there's one thing.
Netherlands, yeah, tell me.
Indeed, the Netherlands, my lords. My lords, the last time I was here on the 21st of August, my lord was pleased to instruct that the.
Today it's not come?
It was listed for yesterday, my lord.
It will come today, give it.
Okay, my lord. In fact, I've already
When are you
spoken.
flying back to Netherlands?
I was supposed to fly back last night. I've extended it. Now I'm leaving on Saturday. My lords, this matter must be heard.
Must be heard, I will not listen to all that.
My lords, I'm just saying it's my submission that it must be heard. The last time around, my lord was pleased to instruct the, Mr. Sanmati, the standing counsel.
We'll see.
That you must
There's no
brief the
must.
ASG.
Yes.
My lord had said you must. That no further, my lords will be pleased. I'll read the order.
All right, don't worry.
Yeah.
Yes.
In that particular case, my lord, you'd said that the ASG has now been briefed.
We'll see.
I've spoken with the ASG. He's been briefed. He's prepared. He's willing to come tomorrow as well. So if we can keep it for this afternoon, I will.
No, we'll keep it for tomorrow.
But my lords, then I have come all the way.
You're not going, you're going on Saturday, you said.
That's right. So I'm here, but I plead with my lords to please hear this matter before I leave because it's extremely urgent. The capital of the company has been
All
taken
right.
away by the.
We'll hear it tomorrow.
My lords, pleased. Thank you very much.
Lord, I'm the purchaser of the property. Last year, they filed a collusive partition. Lok Adalat without getting third party interest. Lord, it may be taken up.
Move the vacation. Yes, next.
Being spoken to serial number 1.
That serial number 56, withdraw, please.
ಅದು ಬರ್ಕೊಂಬ.
I filed the memo. please.
ಆಯ್ತು ಸರ್, ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಕೇಳೋಣ.
Please, my lord.
We'll do it.
Only
Please,
those
my lord,
dramatic-
ಆಯ್ತು, if you are agreeing for something, I will do it.
No, agreeing last time, there is a memo filed. The first
ಆ ಮೆಮೊ
point-
ಪ್ರಕಾರ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು.
No, paragraph 2, I have objection.
ಆಯ್ತು.
Otherwise,
ಪ್ಯಾರಾಗ್ರಾಫ್
I
2
have-
ಏನ್ ಹೇಳಿದ್ದಾರೆ ಸರ್?
Paragraph 2 ನಲ್ಲಿ, he says he has submitted a report from a chart accountant. The rate of tax deduction at source is lower than what we are claiming.
That
That
my
your
lords had
lordship
said
will not
also.
be able to say. It amounts to reviewing the judgment, my lord. Otherwise, we have
See,
no objection.
Senior counsel has gracefully agreed to all others.
My lords had,
Should not-
I'm just trying to apprise my lords of what had happened last time. My lords had said that at the time of them depositing it, my lords will then determine this issue and I can move a memo. So today, in fact, I don't know why it was listed.
I don't know what your lordship
Correct, why
mentioned.
it is listed?
ನನ್ಗೂ ಗೊತ್ತಿಲ್ಲ.
ಇವತ್ತೇನ್ ಡೇಟ್
ನಾನು move
ಕೊಟ್ಟಿಲ್ಲ,
ಮಾಡಿಲ್ಲ.
ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅದಕ್ಕೆ.
Please,
Yes, we'll post it on 30th.
please,
When, if there is any problem, you move it.
please.
As
Yes.
senior counsel said,
Please.
the second portion.
Paragraph 2, my lord, we have objection.
No worries, sir, without hearing you
My
will
lords
not
had
pass it.
clarified saying that that will be at the time of deposit. my lord.
Correct, we'll see, avat ನೋಡೋಣ.
Please, please,
We'll post it on 30th, sir.
please,
30th or 31st we'll post. 31st October.
please, grateful,
In the same stage, ಹಂಗೆ ಇರ್ಲಿ.
please, grateful.
The tax councils are here. A list 2 ಅಲ್ಲಿ ಎಲ್ಲ faceless, all. Sure.
My lord,
My lord, sir. List 2 all are faceless.
my lord. List 2 ನಲ್ಲಿ
ಅದು ಅಲ್ದೇನೂ ಇದೆಯಾ? ಡಿ ಟ್ಯಾಗ್ ಕೊಡಿ ಅದು. ಆಯ್ತಾಯ್ತು. If you've given it to madam, done, don't worry.
They've raised this ground also in that.
Which ground?
This faceless ground also is there. Apart
ಮತ್ತೆ ಅಲ್ಲಿ ಬೇರೆ ಗ್ರೌಂಡ್ಸ್ ಎಲ್ಲ ಆಮೇಲೆ ಇರ್ಲಿ ಬಿಡಿ, ಡಿ ಟ್ಯಾಗ್ ಯಾಕೆ?
Petitioner will not be able to handle a second round. No, the 151 sanction.
ಆತರ ತೊಂದರೆ ಇದೆ. See, if a person cannot handle the second round, then we will not trouble him.
As on today, there is interim order.
There is interim order. I will take a date.
Never come up. That's because it will take time. By
Then it will come, let it come, bidi.
Let the lordships may kindly dispose all the matters.
Ravi Shankar sir, we will dispose all the matters. I am not saying that you will have to file a fresh petition. I have directed revival of these petitions only. ನಿಮಗೆ ಏನ್ ಮತ್ತೆ ಏನು you can't sustain ಅಂತಲ್ಲ ಇಲ್ಲ.
5 matters which are there are primarily on the challenge of 151 unsigned. If that were, my lords were to decide in my favor or theirs. Other matters are there which I could still again persuade my lords.
See, other things I've always kept, you have not seen my order, I have passed a detailed
I
order.
vote on to my lordships on that.
I have passed a detailed order, no other court faceless need be seen. Court's order, because everything is there
One
in that.
item is covered by Rajiv Bansal.
Raju Bansal, ತೊಂದ್ರೆ ಇಲ್ಲ.
The first one is a matter which I.
See, I have no time to hear.
No, my lords.
Faceless idre matra, I have posted them because it is faceless. If that is not there, we will detach and.
In all the cases, there is law. My lordships may.
We'll leave all the grounds open, sir.
Small interjects.
It is always open.
My lord, the 151 sanction, they don't want to argue.
No, even if it is argued, I have no time to hear it.
No, not now, my lords. After vacation, if my lords post.
Dilip, detag, ಎಷ್ಟು ಮ್ಯಾಟ್ ಇದೆ detag?
5 plus 2, my lord.
ಅಷ್ಟೇ. Those ಕೊಟ್ಬಿಟ್ಟು ಮಿಕ್ಕಿದೆಲ್ಲ will say dispose.
Please. Lord, 72 is not a income tax matter. It is GST matter in the second.
Whatever is to be detagged, you can give it to the court officer.
Yes, my lord.
My lords,
If you have given it, no problem.
Yes.
71 is not faceless.
All right, no problem. Yes. Wherever you have given, that will not be disposed as faceless. Interim order, it will continue. It will come after vacation. All right.
Okay, thank you.
Others all second list tax matters, nobody need wait, except these matters which are not faceless. Everything else stands disposed in terms of the faceless order.
I've given my name.
My lord, 70, serial number 71. My lord, serial number 71 is not faceless.
No, madam, don't worry about that. Yes. Yes. ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ ಅದನ್ನು ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ next.
Seal number 2, being spoken to, seal number 2.
I appeal for the petition this matter, madam. My lords,
ಏನ್ being spoken to ಯಾಕೆ?
ಅದರಲ್ಲಿ ಒಂದು ಪೆಂಡಿಂಗ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಏನ್ ಪೆಂಡಿಂಗ್?
It is already disposed, my lord. Already disposed. Order ಅಲ್ಲಿ pending ಅಂತ ಬಂದು 3 months.
ಯಾವ?
Kindly see.
In the light of the prayer being innocuous in the execution, ಈಗ ಏನ್ ಮಾಡೋಣ ಇದಕ್ಕೆ?
ಏನಂದ್ರೆ my lords, my prayer is itself is that my lord setting aside the.
We will restore the file, restore the order.
My lords,
No, don't do all this. The petitioner is before this court.
One submission, if I may, my lord.
Now I have no time to decipher all your submissions and rewrite the order.
One simple question, my lords. Honorable Apex Court has decided on this particular aspect.
ಅದಕ್ಕೆ ಅದನ್ನ ಬರಿಬೇಕು ತಾನೆ?
That itself, my lords, matter will be disposed of. My submission would be, my lords, the annexure A.
Both of you say that it is covered by Apex Court order?
Please.
The same. Apex.
ಕೊಡಿ ಅದು.
My lords, one submission before my lords so proceed. Annexure A is the order passed by the learned civil court, whereas my lords, honorable Apex learned civil court has disposed of the FRP based on the memo. My lords, honorable Apex court in the similar situation, my lords, para 35 last page says, we are of the view that preliminary decree is passed by the trial court. The court should proceed with the case drawing up the final decree suo motu. After passing of the preliminary decree, the trial court has to.
We'll see. We'll dispose it in terms of this. Don't worry.
Yes. ಇದರಲ್ಲಿ ಏನಂತಂದ್ರೆ just one submission, last one.
Time ಇಲ್ಲ ಸರ್. After vacation ಆಗ್ತೀನಿ ಬೇಕಾರೆ.
This matter itself may be disposed of.
That is why dispose ಮಾಡಿದಂತಾನೆ ನೀವು ಹೇಳ್ತಿರೋದು ಇದಿಲ್ಲ. See, one ನಿಮಿಷ. Pending proceedings, you asked for a speedy disposal.
Please.
I gave you speedy disposal. Now your work dispose ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಅಂದ್ರಿ. You have to challenge it in an appeal. Where are you being spoken to ಇದರಲ್ಲಿ?
That is what is my submission, my lords. The very order which is being challenged is itself, my lords, the Supreme Court says.
Sir, GM CPC ಅಲ್ಲಿ I gave you execution proceedings pending ಇದೆ ಅಂದ್ಬಿಟ್ಟು 3 months time. ಆಯ್ತಪ್ಪ 3 months time ಕೊಟ್ಟೆ. ಈ ಆರ್ಡರ್ ಬೇಡ ಅಂದ್ರೆ I'll restore the matter.
ನಂಗೆ ಆರ್ಡರ್ ಬೇಕು, my lords. ಪೆಂಡಿಂಗ್ ಇರೋದು set aside ಅಂತ ಆದ್ರೆ ಸಾಕು. That's all. My lords, why it should be set aside ಅಂದ್ರೆ Apex Court clearly says.
Execution proceedings ಇಲ್ವಾ ಇವತ್ತು?
ಇಲ್ಲ. My lords, my submission would be when there is a preliminary decree, my lords, until final decree is passed, the suit itself is not complete. Now, learned civil court is erred completely.
Sir, that is on the merit of the matter.
ಇಲ್ಲ merit ಇಲ್ಲ.
ಮತ್ತೆ
the very passing of the order.
What passing? 3 months time ಅಲ್ಲಿ ಅದೆಲ್ಲ ಬರ್ಸ್ಕೋಬೇಡಿ ಈಗ.
ಇಲ್ಲ.
Oh no sir.
My lords, my submission would be in the light of para 35 held by the honorable Apex court, suo motu ತಗೊಳ್ಬೇಕಾಗಿದ್ದನ್ನ ಅವರು ಮೆಮೊ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಈಗ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ತಾನೆ.
ನೀವು ರಿಸ್ಟೋರ್ ಮಾಡಿದ್ರೆ
ಒಂದೇ ನಿಮಿಷ. ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟ್ರಿಗೆ ಏನ್ ರೆಮಿಡಿ?
ರೆಮಿಡಿ ಏನಂದ್ರೆ my lords, the
Remedy, one
disposal
ನಿಮಿಷ.
order itself is challenged, my lords.
ಈ ಡಿಸ್ಪೋಸಲ್ ಆರ್ಡರ್ ಅಂಡ್ ಆರ್ಟಿಕಲ್ 227 have challenged?
Yeah. My lords, I have a locus in this, my lords. Kindly see page 19.
Yes, list the matter on immediately after vacation in the same stage. Yes, next.
ಇದರಲ್ಲಿ one last submission, if I could.
No, sir. Yes, next.
Number 3.
You have taken an order for 3 months speedy disposal and you are enlarging the scope to
not at
such
all.
an extent that we'll have to pass an order on merits.
Not at all, my lords.
No,
My lords,
sir.
my request.
Not under being spoken to, you file a review.
No, my
The
lords-
petitioner is wanting to enlarge the scope of the order that is already passed in the garb of an order under being spoken to. Being spoken to undoubtedly is for correction of errors. There is no error except error. The learned counsel for the petitioner submits that the finding
I'll
was
come after vacation.
was that the finding rendered was to dispose the execution proceedings within 3 months. As on the date of rendering the order, the execution proceedings itself had been disposed of.
That itself is my prayer, my lords.
One nimisha, sir. Itself had been disposed of. Therefore, the petitioner shall file a petition seeking review of the order and not on being spoken to. Reserving such liberty, petitions, the no further orders need be passed. Next.
Number 3.
P&S.
ಇದು ಅಷ್ಟೇ. You have to ಎಲ್ಲರನ್ನು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಲೇಬೇಕು.
ಅಲ್ಲ citation ಕೂಡ
ಕೊಡಿ, citation ನಾನೇ ಕೊಡ್ತೀನಿ, ಕೊಡಿ. ಎಲ್ಲ ಕೊಡಿ.
283 specifically says that.
No problem, sir. Yes.
Issue citation. For that regard, we have issued the citation by
We'll
way
see,
of
we'll-
paper
we'll-
publication in the local.
The petition was heard and disposed in terms of an order dated so and so. The order that is, the judgment that is relied upon by the learned counsel for the petitioner, the law in the judgment relied on by the learned counsel for the petitioner has undergone a change. Therefore, the matter requires to be heard. Post the matter immediately after vacation for further hearing. Interim order, yeah?
ಇಲ್ಲ sir.
Yes, next.
5 is also similar. my lord.
Same. 3 and 5, same order. Order recalled, post the matter for further hearing. Next. 5 also same.
Number 4.
4, my lord, there's a rent deposit matter. My lord, there's a small error that.
After vacation. ಏನ್ ಕೇಳಲ್ಲ ನೀವು?
ಏನಿಲ್ಲ, I'll take 1 minute, otherwise my lord, I'll leave it.
We'll take it at the end of the day. You finish all your work and come.
Then your lordship may keep it.
Okay, you are not coming back to the court?
Bit unwell, my lord, otherwise.
You are unwell.
All right.
After vacation.
I leave it.
Immediately after vacation.
Please, as your lordship.
ಅಷ್ಟ್ರಲ್ಲಿ ರೆಂಟ್ ಸೆಟಲ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
ಆಗೋಗುತ್ತೆ. Only thing is, my lord, the period prior to the suit is all that I'm requesting, because there is a dispute that has been
Yes,
raised.
Sunil.
The order of the civil court says,
So-
commercial court says, from the date of the suit, I'm paying that.
So when it comes to money, nobody agrees. So you better drop something and come, or you take my order, whatever it is.
There is already an order by the coordinate, Justice M.I. Arun.
Correct.
Lord Justice M.I. Arun's order says, subject to what order the civil court would pass. Civil court has said from the date of the suit. That's, my lord, the only thing.
Yeah, that you have challenged.
The writ court's order, my lords, is now getting diluted because of it.
No, it is not
Alla,
dilution.
Justice M.I. Arun ಅವರು from the date of the
They
suit
want
ಅಂತ
to
ಹೇಳಿದ್ರ?
challenge that order.
I'm not
They want to
challenging.
challenge that order by being spoken to, saying.
I'm not challenging any order. Let me learn it from.
So what did the coordinate bench?
M.I. Arun's court said, deposit the rents in terms of the lease deed.
In terms of the?
Lease deed.
ಆಯ್ತು.
Then, my lords, the trial court said, no, please deposit from 1/4/2020, 2024.
2020? 2020, 1/4/24.
Yes, 1/4/2024.
1/3/24.
1/3/2024.
That is the date of the suit, my lord.
ಆಯ್ತು. ಈಗ ಲೀಸ್ ಡೀಡ್ ಯಾವತ್ತು?
Lease deed dates back to July 2022. They say there is a rent-free period of 7 months within that.
All right, 7 months, July 22.
What your lordships have said is.
March
after
23.
After the rent-free period, please deposit.
I'll
the
just
rent. That's
take a
what your
minute.
lordships have
Now,
said.
who
I
has
was
moved this
actually-
for being spoken to now?
I was
So there is no-
actually put in possession, not even in, after the rent-free period, but only in June. And I was not allowed to use these premises. There are, my lord, 2 parts to this. One is, insofar as North Tower, there's a portion where I have a registered lease deed, there I paid fully. Insofar as this portion, since there was some disruption, my lord, that is subject matter of the suit. That's all I'm saying.
Sir.
Lordship may
if-
kindly permit me.
No. If this coordinate bench has said,
Yes,
where is that order?
Please take that order, my lords. Can I just draw the court's attention? Please be kind enough to take page 128.
Then we'll post this matter before the same honorable judge.
In fact, your lordships have passed an order.
I'll,
On their own
I'll leave that, my lord. I'm not saying it. It's actually a very simple
They
point.
made the
Sir, one
submission.
second, sir. One
Order
second.
ಕೊಡಿ.
It has been moved by.
Annexure F, my lords.
129.
129, your lordship, please.
1 minute, sir.
I'm sorry, what was moved was by us. Let me make out why I'm asking for a correction before
One
my
moment,
learned friend's
sir.
anxiety.
Which is the,
129, your lordship, please. See, my lord.
which is the order that I have passed?
My lord, your lordship's order, I don't think is yet released. My lord. That's,
Howda? Oh, it is kept because of this.
it's kept because of this. It's kept for being spoken to.
Hmm.
Could I draw the court's attention to 128? Orders disposal starts there. Please look at Roman 3. I'm sorry, yes, Roman 3 at page 129. Interim order passed by this court on 24/4 shall be enforced till the decision that may be taken by the trial court on IA is pending. 4 says petitioner shall deposit rents as ordered by this court on 24/4 by next date of hearing if it is not
24/4,
already
what is the order?
Order says in terms of lease deeds.
Anything else? sir?
127.
No, that's all.
In
All
terms
I'm
of
saying
lease-
is trial
In terms
court
of
would
lease
say
deed,
one.
you shall pay, sir.
I will do it. That's all. Nothing more.
First.
In terms of lease.
I would,
That is exactly
your lordship may
what-
just make that.
They said that they don't want a council submission, let it be judicial.
That's all, my lord, I'm asking.
ಅಷ್ಟು ಅವಾಗ್ಲೇ ಹೇಳಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು ಇಷ್ಟೊಂದು. ಕೇಳಕ್ ಬಿಟ್ರೆ ತಾನೆ. Yes.
ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ
ಅಲ್ಲ ನಾನು
ಮಾತಾಡ್ತಾ
ಹೇಳಕ್
ಇದ್ರು.
ಬಿಟ್ರೆ ತಾನೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ ಮಾತಾಡ್ತಾ
The
ಇದ್ರು. I
petitioner-
pointed out only this.
ಯಾವ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಯಾವತ್ತು ಸುನಿಲ್?
Yeah, when was the date of disposal?
19/9. The subject petition stood disposed in terms of an order dated 19/9/2025 by observing that the lease deed contained 7 months of rent-free period, and therefore the rent has to be calculated from the date on which the 7 months period would get over. The learned counsel for the learned senior counsel, Shri C.K. Nandakumar, has moved the matter on the score that the order needs to be clarified with regard to the date of date of commencement of the rent to be paid. The coordinate bench of this court, while disposing writ petition 11798 of 2024, had observed as follows: para 7, page 128, 129. The coordinate bench had directed following of the order dated 24/4/2024. 24/4/2024 order reads as follows. ಎಲ್ಲಿದೆ ಅದು?
Page one.
My lord, it's extracted in the very order that your lordship should get at page 126.
2024 order reads as follows. Page 126 ಅಲ್ಲಿದೆ. The order was unequivocal that the rent would commence from the date of the lease deed. In that light,
In terms of the lease deed, not your lordship.
in terms of the lease deed, the rent would commence in terms of the lease
I'm
deed.
great.
The learned counsel for the petitioner submits that this is respondents, learned senior counsel submits this is a clarification that was needed. Therefore,
The order of the trial court says from the date of the suit. That's-
the learned senior counsel submits that the order of the trial court has generated certain obfuscation, as it says from the date of the suit. In the light of the order that is already passed by the coordinate bench that the rent would commence in terms of the lease deed, the order of the concerned court would run foul of the order of the coordinate bench. In that light, I deem it appropriate to clarify that the rent would commence in terms of the lease deed and not from the date of the suit.
Great.
Date of the suit. This order shall be treated as part and ಇಲ್ಲ ಇನ್ನೂ ಸೈನ್ ಮಾಡಿಲ್ವಲ್ಲ.
ಮಾಡಿಲ್ಲ ತಾವು.
This order,
One further request, my lord, subject to adjudication in the trial.
all this would remain,
I'm great.
all this would remain subject to the adjudication pending before the concerned court, ordered accordingly.
One line. Post the rent-free period.
ಅದು ಹೇಳಿದೆ
Yes, of
ಫಸ್ಟ್
course,
ಹೇಳಿದೆ
of course.
ಅದನ್ನ.
Till the date, of course, that goes with that.
First,
Great.
yes. ಈ ಆರ್ಡರ್ ಬೇಡ, ಈ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಮಾಡಿ, ಈ ಆರ್ಡರ್ ಮಾಡಿ, ಇಲ್ಲಿದೆ ಆರ್ಡರ್ ಜೀವ ಇದೆ.
But in the other matter, there's no controversy. That is completely paid in.
Yes, yes. Next. Disposal today. ಅವತ್ತಿಂದ recall ಮಾಡಿ disposal today. Yes. ಅದ್ ನಾನು ಹೇಳ್ತೀನಿ ಅಲ್ಲಿ.
Order still number 6. 24/10.
ಹಾ.
9 and something.
My lords have given a date.
24/10, yes, by mistake. Yes. This
Interim
matter on 24/10.
Interim order.
Interim order subsisting would continue to the next date of hearing.
7.
Respond number 2, my lord.
Recalling the order.
Respond number 1, my lords.
CRP, my lords.
Appeal is not maintainable.
Section 8 not maintainable, my lords.
Covered, sir.
Even after my lords have disposed it, they moved it again, secured an interim order and they're delaying proceedings there in the
Yes, sir.
trial, my
Anything else?
Hey.
Really judgment ಕೊಡಿ, ನಂದೇ judgment ಇದೆಯಲ್ಲ.
lords. Please, my
Pass
lords,
over.
I'll
No,
file.
sir, it is covered.
My lords, in any case, my lords,
227 is not maintainable.
my lords, I'll file the judgment. Section
I
8,
produced one judgment.
It was
also,
later one, sir, 2025.
my lords, legislative bar is clear, my lords. Section
No,
8 of Commercial Courts Act, there is a bar on
No,
revision
sir.
against any.
Period, pass over. Yes.
My lords,
Evening, I'm going to dismiss it. Yes. whatever the
My lords,
time.
in the-
Another matter at 81 serial number.
Other matter, yeah.
81 my
ಎರಡು
lords.
ಒಟ್ಟಿಗೆ, we'll take it.
My lords, make a submission, my lords. I'll file the judgment, my lords, section 8 of the.
ಈಗ ಮಧ್ಯಾಹ್ನ ಬರಲ್ವಾ?
Sorry.
Even if it is 7 o'clock, we'll close this.
Please.
Yes, next.
Number 8. Appearing for the petition. This is relating.
After vacation, yes. ಏನ್ ಮಾಡಿದೀರಾ?
My lord, we have now.
List the matter on 25th. Yes, next.
Lord, after vacation.
ಅದೇ 25th October. October 25th. Yes, madam, seriously.
9.
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ವಾರಂಟ್ ನ? ಯಾಕೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ? ಹೂ ಇಸ್ ದಿ ಯಾವ ADLR? ಅದರದ್ದು ಸೆಕ್ರೆಟರಿ ಯಾರು? Secretary to be present before, secretary, who is the head there?
SP.
ಏನ್ SP? ADLR head ಯಾರು? DDLR ಯಾರು? Commissioner ಯಾರು? Commissioner, list tomorrow. The commissioner of another survey settlement and land records shall be present before the court at 10:30 AM. Yes. The order, the carbon copy of this order shall be furnished to the AGA forthwith. Yes, next.
10. Withdrawal option.
In terms of,
11 also.
in terms of,
12.
ಇದೇ ತಾನೇ ದುಡ್ಡು ವಾಪಸ್ ಅಂತ ಹೇಳಿದ್ದು.
This ಮೇಲೆ.
ಆಯ್ತು, we'll hear it after vacation. Please list the matter on 30th for 31st October for further hearing.
Third, it is
I have heard it completely. ಅದಕ್ಕೆ
only regarding the payment.
ಆಯ್ತು, ನೋಡೋಣ ಅವತ್ತು ನೋಡೋಣ.
My lord, we have filed an impleading application in 12.1, my lord. We have filed an impleading application that is not reflecting, my lord.
ಆಯ್ತು, we'll do it on 31st, don't worry.
Please, my lord.
Interim order subsisting will continue to the next date of hearing.
Please.
Ultimately, ಅವ್ರು ಯಾರಿಗೂ ತೊಂದರೆ ಆಗಬಾರ್ದು ಅಷ್ಟೇ.
That's all.
We shall see.
13.
But this matter, they are not appearing. Last time, my lords passed an order. If they would not appear, it would be dismissed for non-prosecution.
ಕೊಡಿ.
It's covered, my lord, now by a.
Covered ಎಲ್ಲ ಇಲ್ಲ. Wait.
ಅಲ್ಲ, ಇದೇ ಕೇಸಲ್ಲಿ.
ಯಾರು ಸಂಗಮೇಶ?
13.
13.
14 and wait.
13. This court on 17/9/2025.
I'm sorry, I'm in 13 words.
ಯಾವ್ದು?
13.
Agra legal.
Yes, my lords. I am permitted to file the wakalat for the petitioner, my lords.
We'll dismiss it today. You seek recalling.
May I make this submission?
What is all this?
I'm sorry, my lords, but then.
ಯಾರು ಬರೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ stay ತಗೊಂಡ್ಬಿಟ್ಟು?
ಅಲ್ಲ,
We'll vacate the interim order now.
ಅಲ್ಲ, ನನಗೆ interim order ಬೇಕಾಗಿಲ್ಲ. It may be vacated, my lords, but nevertheless, my lords, the auction has taken place before the
The
execution.
learned
court.
counsel appearing for the petitioner submits that pendency of the interim order is of no avail. In the light of the said submission, the interim order stands vacated.
May I make
The
this
learned
submission?
counsel Sangamesh first Haked has entered appearance in place of the petitioner, registry to print the name of so and so as appearing for the petitioner. List after
Lords,
vacation.
May I make one submission? Lords, hospital
ವಕಾಲತ್ ಹಾಕ್ತಾ
equipments.
ಇದ್ದೀರಲ್ವಾ?
ವಕಾಲತ್
ಓದ್ಕೊಂಡು.
I'm fine. Lords, the hospital equipments have been auctioned before the trial court. Lords, the equipments are auctioned and it is just pending there, my lords. Let it be pending there at that status is my humble submission.
Lord, that is not the scope of this writ petition. Here, the immovable
Because-
property is involved, my lord.
Interim order is vacated. You
Because-
take chance after vacation. Next.
I may permitted to file wakalat. It may be accepted.
Registries.
Very well.
Yes.
My name may kindly be deleted.
Delete the name of Kashyap Naik and print the name of Sangamesh.
RB, my lords.
RB, yes.
Obliged.
ಕೊಟ್ಬಿಡಿ ಇಲ್ಲೇ ಹಂಗ ಬರಲ್ಲ, ಯಾಕೆ ಹೇಳಾಯ್ತು. Next.
14.
For the petitioner, my lords,
I
having a
appear for the
copy of the order, my lords, in a
respondent.
similar matter, same property, my lords,
My lords,
same
one
parties.
humble submission,
It's an
my lords.
eviction suit, my lords.
My lords, the statement of
It's not-
objection
not the
was
same?
ready, my lords, so far as the representative has delivered the child. So that is why we couldn't secure the signatures for the affidavit supporting the statement of objection. 2 weeks' time may be granted.
Interim order ಇದೆಯಲ್ಲ ಪ್ರಸನ್ನ?
ಇಲ್ಲ, my lords, the interim orders for stay of proceedings, my lords. It's an eviction suit, it's a commercial property, my lords.
Not
4.5
similar,
crores is pending. Now, my lords,
For
the same building, my lords, between the same parties. My lords have passed an order where 40% deposit of rents was directed, my lords. I mean,
What is the order under challenge here?
my lords, the order under challenge, my lords, is an order permitting the respondents to file where they were placed ex parte and the matter was posted for judgment, my lords. The matter was posted for judgment in,
I may be permit-
Same order will pass, madam.
same order can be passed, my lords.
There is one humble submission, my lord. I will file my statement of objections
Madly-
meeting this ground.
The learned counsel for the petitioner submits that the issue in the list stands completely answered by what is
Please.
ordered in writ petition 6181 of 2025, disposed on 7 July 2025. The learned counsel appearing for the respondent, though would accept that the matter stands covered, would seek leave to file statement of objections, formal statement of objections as the respondent is not available for a signature on the affidavit. Therefore, list this matter on 8th October.
Please.
Yes.
Interim order.
Interim order subsisting will continue to the next day.
15.
Yes, we pay for the
Post
petition,
immediately after service of notice upon the respondent.
submission, my lord. Already but serve the copy.
No problem.
but,
Yes, next.
Kindly accommodate, because there is 27, this order is going to post in trial court, my lord.
ಏನು matter ಏನು?
But it's implementing application rejected by the honorable.
What interim application?
Implementing application.
Order 1 Rule 10.
Please, my
Who
lord.
are you? What suit for?
Suit for declaration, because I am in position last 20 years, my lord. They are only respondents, only on waivers. They are collaborating with the government officials to transfer the property, my lord. Kindly see the annexure E, annexure E, page 39, my lord. Annexure E, page 39. ಅನುಮೋದಂತೆ ವಿವರ and RTS ಅಂತ ವಿವರ. ಅನುಮೋದಂತೆ ವಿವರ serial number 3, 23/3, 2 acres, Gangana, Ben Chikkabbanappa. They are my
Let
grandfather.
it come. Yes, after vacation.
Sir, please date.
No, sir.
Date may be accommodated.
No, nothing. Yes. Date will give. List the matter on 14th October. Yes.
Please.
Next.
16. Withdrawal motion.
In terms of
17.
after vacation. Interim order
18.
continue ಮಾಡಿ.
Petitioners. The petitioners, interim order is there.
After vacation.
Interim order.
19.
2 weeks to do the needful. Next.
Interim order may kindly be.
In the event needful is not done, interim order would stand automatically vacated. Yes.
20.
Post immediately after service of notice upon the third respondent.
Interim order may be extended.
Next.
21.
That's a vacant process. I've done the needful, my lord.
Lieutenant counsel submits needful has been done. Office to verify.
Interim order may be kindly.
IO. Chetan ಎಲ್ಲೆಲ್ಲಿದೆ IO ನೋಡು.
22.
It granted the interim stay on the technical ground.
Madam, one ನಿಮಿಷ. Yes.
Your lordship can dispose this matter, my lordship, remand back the matter to the authority for consider on the
ಯಾವ್ದು?
22.
22.
Technically,
Post immediately
they
after service. Third respondent ಯಾರು?
to South Africa.
South Africa.
This, my lord.
Third respondent, my lords, is the
South Africa.
party on, at the behest of which the impugned order was passed. The third respondent, my lords, was
The
a
agency.
non-tenderer. Non-tenderer preferred an appeal
Oh,
under
GM
section
matter,
16. Yes, my
GM tender, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು 16 ಅಲ್ಲಿ ಅಪೀಲ್ ಆಗ್ತಾರೆ ಥರ್ಡ್ ಪಾರ್ಟಿ. That is blindly considered by the authority. Your lordship, on that ground alone, your lordship stay the order. That is why you remand back the matter by.
ಇರ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes, so and so.
ಅಲ್ಲ,
Where detailed order is passed.
that is why my lordship, I requested
List the matter after vacation. Interim order subsisting will
Date may
continue
be
the next
given.
date of hearing. Yes. GM ಅಲ್ವಾ?
20.
Yes,
ನಮ್ಗೆ
next.
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದಕ್ಕೆ.
ಈ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ? Yes, list the matter on 8th October. Yes.
Yes, my lords.
23.
For the petitioners, 2, 4, 5 are not a contesting
Huh?
parties. Two, respondent number 2, 4 and 5 are not a contesting parties, my lord, they placed there.
Learned counsel files a memo, so and so.
1 and 3 are, my lord, the council is served for 1 and 3.
List after vacation. Yes.
Yeah, the interim order may be.
Interim order subsisting. Next.
Date may be.
24.
Date.
ಅರೆ
ಇದರಲ್ಲಿ
ಆಮೇಲೆ
ನಮ್ಮದೇ ಸೂಟ್ ಇದು.
ಅಲೋ ಮಾಡ್ಲಾ ಈಗಲೇ?
ಸೂಟು.
ಅಲೋ ಮಾಡ್ಬೋದಾ ಈಗಲೇ?
ಅಲ್ಲ.
ಬನ್ನಿ ಸರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಎಲ್ಲ ಇವತ್ತೇ ಆಗ್ಬೇಕು ಅಂತ.
ಸೂಟು ನಮ್ದೇ ಸರ್, ಹಂಗಾಗಿ ನಮ್ಮ ಸೂಟ್.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನೀವು ಕೇಳಿದ್ದೀರಾ, ಕೊಟ್ಟಿದ್ದೀವಿ. ಇಂಟರ್ ಮಾಡ್ರೆ ವೆಕೆಟ್ ಇದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದು ಬೇಡವಾ?
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡು.
ಮತ್ತೆ
24. Entry mark.
24, 2 weeks to do the needful. In the event needful is not done, automatic interim order stands automatically vacated. Subject to the said condition, interim order stands extended.
Please apply.
Next.
25. Withdrawal motion.
In terms of
26.
Filing the memo for sufficiency of service of notice and dispensation of notice to respondent number 10 to 20.
Dispensation kodi first.
State.
After vacation, IO.
Please, my lords. Lord, this sufficiency of service, my lords, because my lord, the caveator who is the Mahesh is the GP holder of respondent number 1 to 9, my lord. To that extent, already the caveat has been filed, my lord. That extent of filing that memo.
I register lack here. Yes, interim order there.
Interim order.
Yes, next.
27.
Lords, notice against R1, 2, 6 to 8 may be dispensed with, my lords. And so
Memo,
far as-
memo.
Yes, please. I'm filing memo.
Vijay, memo.
Lords, one humble submission is
After vacation, IO.
some date may be fixed, my lords.
28.
Please, great.
My lord, appear on behalf of the petitioner. The process fee is paid this morning.
Then the council submits, needful has been done, office to verify. IO. Yes, sir.
29.
Will undertake to file wakalat for respondent.
Learned counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. The service of notice is thus complete. Left after vacation. IO.
Date, my lord?
30.
Move ಮಾಡಿ.
30.
For the petitioner.
Interim order.
Post immediately after service of notice upon the respondent. IO. Next.
Grateful.
31.
Appearing for the petitioner, senior appointment of court commission matter. My lords had posted.
31 now. What do we do now? This is my order only earlier.
Senior colleague is not in town. That
I,
is to inform the
idella,
others.
don't tell me all this.
Dictating orders
Senior
on
colleague
the-
is not in town, junior colleague should be ready. This is an order that I have passed, sir.
Not in-
It's
not
my
in-
order.
Yes, your lord.
Then I have, nobody else can interpret my order. Then
Date may be given.
ಈಗ ಯಾರು ಬೇಕು ಹೇಳಿ?
Suppose ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ಅದು ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋಣ ಹೇಳಿ?
My lords, so far as the I'm not in record. That is senior colleague is not in the-
WP 21514 is concerned. Adu, my lords had observed that let Tahsildar only be there, so that can be dismissed. They also had agreed last time.
ತಹಸೀಲ್ದಾರ್ ಬೇಡ ಅಲ್ವಾ?
Tahsildar Beku, they are contending that ADLR has to be appointed.
ತಹಸೀಲ್ದಾರ್ can be.
Can be. So that can be dismissed, my lords.
You are not on record now?
Not on record.
ಓ NOC ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, recently got enrolled 2 months back.
Recently got?
Enrolled 2 months.
You
back.
are?
Yes.
Oh, 2 months is more than enough. Tell me.
But AB exam clear ಆಗಿಲ್ಲ ಇನ್ನಾದ್ರೆ ಅದಕ್ಕೆ
ಓ, then ಅದು ಅಪಿಯರ್ ಆಗೋಂಗಿಲ್ಲ ಅಂತ.
ಅಪಿಯರ್
ನಿಮ್ ಸೀನಿಯರ್ ಕೊಲೀಗ್ ಇಲ್ಲಿ?
ಟೌನ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಇಲ್ಲ ಎಲ್ಲೋ ಈಚೆ ಹೋಗಿದ್ದಾರೆ. ಮಂಡೇ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು.
ಸೀನಿಯರ್ಗೆ ಜೂನಿಯರ್ಗೆ ಮಧ್ಯ ಯಾವ ಕೊಲೀಗ್ ಇಲ್ವಾ?
ಅಂದ್ರೆ ಮಂಡೇ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು.
My lords,
We were
they
ready,
had
but
addressed their arguments on the last occasion.
ಆಯ್ತು, we'll list it tomorrow. If you don't make arrangement, we'll dismiss this. List tomorrow.
Friday.
No, tomorrow. Wherever he is not in town, ask him to come. Yes.
Great.
Next.
32.
Post immediately after service of notice upon respondents 1 to 6. I void it. Needful to be done in the meantime. ಏನಿದೆ madam? Served before. ಇಲ್ಲ, ಬೇರೆ ಏನಿಲ್ಲ. Yes, Pradeep?
I have served them, my lord. I filed the acknowledgement in the registry yesterday, my lord.
Yes.
Here. My lord, here.
2 to 4.
Non-filing. Okay, respondent ಈಗ. Learned counsel so and so.
4. I have filed wakalat.
Learned counsel so and
No
so
problem.
submits that he has
I'm not-
entered appearance for the respondent. Registered to print the name of so and so. Yes, sir.
Shivaswamy,
ಅದು ಗೊತ್ತಾಯ್ತು.
without any initial. Without initial.
ಶಿವಸ್ವಾಮಿ ವಿತೌಟ್ ಎನಿ ಇನಿಷಿಯಲ್.
I already filed wakalat.
Yes.
My lord.
ಅದು ರೆಕಾರ್ಡ್ ಮಾಡಾಯ್ತು.
Please.
Don't put
Responding to
initial.
3 and 4.
Yes.
My lord, petitioner herein.
ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ? ಯಾಕೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ?
Because I am impleading application ರಿಜೆಕ್ಟ್ ಮಾಡ್ಯಾರ.
ಅಲೋ ಮಾಡೋದಾ? ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಬೋದಾ? The petitioner is before this court seeking the following prayer. The petitioners are impleading applicants 1 to 4 seek to implead themselves, partition suit, into a suit instituted seeking partition, separate possession. FDP la. Seeking to implead in FDP 7 of 2020. The learned counsel for the petitioner submits that the petitioner was not impleaded in the original suit.
Here for respond number 1, my lord.
ಏನ್ ಹೇಳ್ದೆ? I was not implemented in the original suit, which ought to have been done. And therefore, therefore the applicants prefer an application seeking their implemented in the final decree proceedings, which comes to be rejected on the score that they were not parties in the original suit. The learned counsel appearing for the respondent, i.e. the contesting respondent, would not dispute the position that the petitioners are proper and necessary parties to the list, and therefore would submit that the application be, therefore would agree with the contention of the learned counsel for the petitioner. In that light, I deem it appropriate to dispose the petition. I deem it appropriate to obliterate the order and allow the application so filed by the petitioners before the concerned court seeking their implement into the FDP proceedings for the reason so and so allowed cost. The application filed by the petitioner before the concerned court stands allowed.
So grateful.
34.
Yes.
I have filed my wakalat yesterday.
Learned counsel, yarige? Rera.
2 R4, R5, my lords.
Learned counsel so and so. The tribunal constitute agilva inno. Appellate authority agilva.
Appellate tribunal is constituted.
Chairman is also there.
Please.
Chairman is in charge, my lord.
Then what's the problem, madam?
Is my lord.
It's a past order by adjudicating authority under
So?
section 71(3).
43 al appeal ide.
My lords, section 44, subsection 1 clearly gives the power to the appellate tribunal to adjudicate on the orders passed by the
Adjudicating officer.
Subsection
File an
44.
Tomorrow.
No, it was interim order was granted because you said there was the appellate authority is not constituted.
Lordships, the chairman was not there.
Hey, is there?
In charge chairman.
So what?
They'll not hear the matter and pass orders.
No,
Lordships.
who said?
My lord, they're very much doing it from more than 1 year, my lord.
Don't tell me all this.
The reason is- may I
Pass over,
request-
get senior, pass over.
Tomorrow,
Yes.
Your Lordships.
No, no.
Today there's some inconvenience. tomorrow, Your
Nothing. He was there for in the morning. No problem. Get him.
Arbitration
Otherwise, I'll
is-
vacate it. Yes.
No, no,
Come at 6 o'clock. Yes.
Tomorrow, Your Lordships.
Come at 6
Today,
o'clock.
full day
Yes, next.
arbitration is there, that's the reason.
So then we'll
Sorry,
vacate the
Your
interim order. Next.
Tomorrow, Your Lordships.
No, on these grounds, don't take interim order and do it. Let's tomorrow in orders. Yes.
Tomorrow till then.
Interim order till then, ashte. Next.
But there is one small submission. The inspection report. has
Sir,
all-
merits ಮೇಲೆ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಸುಮ್ಮನೆ. ನಿಮ್ಮ merits ಮೇಲೆ ಹೋಗ್ಬೇಡಿ ಈಗ. Yes.
35.
Representing the respondent number 2, my lordship. Yesterday I filed wakalat on
Learned
behalf-
counsel so and so submits that is entered appearance for the second respondent registry to print the name of so and so as
My
appearing for the second respondent.
I will submit one thing, my lordship.
One thing.
My lordship, suit for recovery, my lordship. We filed the execution petition. Then they filed the one more writ petition. In writ petition, my lordship, they undertake to settle the issue and withdraw the petition. Then my lordship.
Serial number ಏನಿದೆ?
Serial number 35.
35.
As on today, my lordship, my due is more than 25 lakhs.
7 lakhs, not chit amount. I am a guarantor. There are other guarantors.
Guarantor ಎಲ್ಲ ಒಂದೇನೆ.
ಅಲ್ಲ, correct. There are other guarantors. my lord.
ಪರವಾಗಿಲ್ಲ ಈಗ
I have paid, not 8.
25 lakhs due ಇದೆ ಸ್ವಾಮಿ.
ಈಗ ಇವ್ರದ್ದು ಎಷ್ಟು?
With interest. The chit amount
25
is
lakhs is due amount as on decree.
not chit amount is 10 lakhs. Not the sir. It's 3 ಲಕ್ಷಕ್ಕೆ ಬಿಡ್ ಆಯ್ತು.
ಈಗ ಇಂಟರ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದೀವಲ್ಲ?
ಇಂಟರ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಎಂಟೈರ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು.
10 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
Lordship, I'm not kindly.
The petition, this court on 3/9/2025.
Earlier round of litigation, I have paid 5.5 lakhs, my lord. I have paid 5.5 lakhs by virtue of the interim order.
ಈಗ
I'll
this
pay
is
now.
blanket stay, sir.
Chit fund, my lord.
Chit fund. It's become cheat fund. Wait, sir.
Lordship, I'm not. I'll deposit
Nothing.
5
Yes,
lakhs.
yes.
I'll deposit 5 lakhs. 5.5 lakhs ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾವ
ಅವರು
ಮಾಡಿದ್ರು?
ಬೇರೆ
Agree with part
Earlier round
payment
of
is made, my lordship.
This
but,
court on
No,
3/9,
with
sir, you want
interest.
the interim order to be extended?
Extended.
Yes. This court, owing to the submission of the petitioner, had granted an interim order of stay which reads as follows. The issue arose out of execution proceedings. The learned counsel for the respondent submits that the petitioner entered into a compromise that he would pay the entire amount.
you submit, we pay entire amount, but as on today, our due is more than 25 lakhs.
Would pay the entire
Interest.
amount. As on today, the learned counsel for the respondent submits that the due is more than is 25 lakhs.
25 lakhs.
Therefore, if the interim order has to be extended, it cannot be unconditional. The interim order stands extended subject to the condition of deposit of rupees 10 lakhs in the next 4 weeks, list after 4 weeks.
I have paid 5.5 lakhs.
No problem. Next, apart from the 5.5 lakhs that is already paid. Next.
Notice to other respondents not required, my lord. Notice to other
You
respondents.
deposit ಮಾಡಿ. In the event the deposit would not be made, the interim order would stand automatically vacated. Yes, next.
The lordship make 6 weeks, my lord.
It's 6 weeks.
36.
My lord, I appear for respondent number 1 to 4, my lord.
I will file Wakalat, my lord. They have not served the my lord, writ petition copy.
14, sir. Insofar
And
as respond-
other
five to-
respondents, my lord, they are
Maybe it
colluding
depends,
with each
sir.
other, my lord. 5 to 8.
Yaud, sir?
Lord, serial number 36.
36.
What's the matter?
Lord, 21 rule 97 application, please, my lord, rejected without there being any inquiry.
Not necessary, sir.
Lord, the
I have
judgment-
distinguished it. Not necessary at all.
Lord, one judgment, please.
One
my lord.
judgment, I'll give you 5 judgments. 2197, no inquiry not required.
My lord, what has happened, please, my lord?
What's that? Pellayamma ideyalla?
Periyamma.
Periyamma. 2025.
My lord, the Periyamal judgment, please, my lord. I would also like to distinguish. My
No,
lord, one
no, sir.
opportunity.
I've already distinguished. You like it or not?
My lord, it is only my submission, my lord. What has happened,
No,
please,
Puneet.
specific performance would tell you 21 rule 97 without there being any adjudication, please, my lord. For a moment, kindly this particular judgment.
It is
Periyamal
it
judgment
is a decree by itself. Please file an appeal.
My lord, para 63 nalli Periyamal judgment alli, my lord, only if there is a, my lord, adjudication in the original suit. Here there is no adjudication. My lord, the
My lord, they are
petition-
sisters, they are not necessary
Everything
parties.
you can argue before the appellate court.
my submission is Periyamal judgment alli what, my lord,
I
para
myself
number
distinguished, sir.
ಅಲ್ಲ ಪ್ಯಾರಾ 63 ನಲ್ಲಿ ಅದೇ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 63 ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಇಫ್ ಇಟ್ ಈಸ್ ಬಿನ್
ನಾನು
ಅಡ್ಜುಡಿಕೇಟೆಡ್
ಆಗ್ಲೇ ಹೇಳಾಗಿದೆ. So I have to follow my order at least.
I'll just go through it and I'll make sense.
Tomorrow fresh matters.
ನಂಗೆ ನಾಳೆ ಬೇಡ ಶುಕ್ರವಾರ ಕೊಡಿ
ಇಲ್ಲ ಶುಕ್ರವಾರ ನಾಳೆ.
ಶುಕ್ರವಾರ
Yes, tomorrow.
ಪ್ಲೀಸ್
Oblige, my lord.
Get that order.
37.
For the respondents, copies are not given.
Petitioner, man.
Copies are not given.
I'll serve it right.
The learned counsel of the petitioner to serve set of papers upon the counsel for the respondent list after vacation.
My lord, the interim order may be extended.
Interim order subsisting will continue. Next. Stitch man.
38.
Appear for the petition in this matter. Respondent number 3 and 4 have been duly served. However, for the other respondents, I'll serve it and the interim order may be.
2 weeks to do the needful. Yes.
The interim order may be
Yes. Next.
Time. Full done. I furnished a process. 30 days process.
The submits needful has been done. Office to verify. IO.
Interim order may kindly oblige. 40.
Post immediately after service of notice upon the respondent.
Respondent number 1, my lord. In this case, my lord.
R2 to 8.
R2 to 8, they are not contesting party.
ಅದು ಬರ್ಲಿ ಅವರೇ ಇಲ್ವಲ್ಲ. Yes. After vacation. Yes. Next.
On kind submission, my lord. This honorable court has appointed the court commissioner with the consent of both the parties, my lord. In the last writ petition, they have placed the writ petition that is 22839 of.
ಆಯ್ತು ಬರ್ಲಿ ಬಿಡಿ. Yes. List immediately after vacation. Next.
41.
My lords, your lordships have directed me to serve the notice on the counsel appearing for the plaintiff before the learned trial court, my lords. We have served and memo to that effect has been filed on yesterday, my lords.
Learned counsel submits needful has been done. Office to verify. IO. Next.
My lords, so far as respondent number 3,
ಇಲ್ಲ, ಆಮೇಲೆ. Next. Yes.
I may be permitted to serve on them, my lords.
Next. Next.
I'm great.
42.
Lord, I appear for the writ petition, my lord. Copy has been served as directed and process has also been paid.
And for respondent number 1, my lord. My lord, one of the grounds that has been raised by the petitioner is that instead of reopening the execution proceedings, I should have filed a separate miscellaneous petition. In the
What is
light
under
of-
challenge?
My lord, challenge, my lord, is my lord, the executing court, my lord, after having closed the execution proceedings, in view of a Supreme Court judgment, my lord, wants to, my lord, without hearing me, appoint a commissioner and, my lord, go into the issue of, my lord, bifurcation of the land, etc. My lord, I pointed out, my lord, I need to file
List on
objection.
8th October.
My lord, I like to make a
Interim order
submission.
subsisting will continue to the next date of
My
hearing.
lord, one submission, my lord.
8th October, sir.
Because that submission, because that ground has been raised, that I should have filed a separate miscellaneous petition. I will do that, my lord. I will file a separate miscellaneous
Alli.
petition. Yes, my lord, before the executing court.
Then we'll allow this.
It may be allowed, my lord.
All right, Kodi.
Yes, my lord. Subject to, I also reserve the liberty, my lord, to initiate proceedings against the petitioner for making a false statement. before this
ಅದೆಲ್ಲ
court, my
ಮಾಡ್ಕೊ
lord.
ಅದೆಲ್ಲ separate. I will not observe anything about that. The petitioner is before this court seeking the following prayer. Heard the learned senior counsel as Sriranga appearing for the petitioner and the counsel for the contesting respondent, the respondent. The petitioner is before this court calling in question certain proceedings before the executing court executing court, which according to the counsel for the petitioner travels beyond the scope of execution. The learned counsel for the learned senior counsel submits that in miscellaneous ಹಾಕಿರ್ಲಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. I
The
just
learned
reopened
senior
the-
counsel submits that the application seeking appointment of a court commissioner is allowed by the concerned court and in the favor of
My
the
lord,
respondent.
it's not yet been allowed, my lord. He wanted to pass orders on that. I wanted to object to the application for.
The
appointment
learned
of-
senior counsel submits that an application for appointment of court commissioner to conduct survey was to be ordered. At that juncture, the petitioner is before this court. Petitioner had to knock at the doors of this court. The learned counsel appearing for the respondent submits that the ground inter-alia projected by the petitioner is that it could not have been filed by way of an interlocutory application, but should have been through a miscellaneous application. The learned counsel submits that the petition be allowed and the learned counsel, the respondent submits that the petition be allowed, the impugned order be quashed, reserving liberty to the respondent to file a miscellaneous application seeking the same relief. The learned counsel for the petition, senior counsel for the petition would not dispute the said submission. In that light, I deem it appropriate to pass the following order. The allowed quashed, the liberty is reserved to the respondent to file appropriate application, i.e. a miscellaneous application seeking the relief that he has sought for. In the event such an application is filed, the concerned court shall consider the same in accordance with law after hearing both the parties and pass necessary orders without being influenced by the orders that are already passed, impugned herein, which are now set aside. Ordered accordingly.
Grateful.
Yes, next.
My apologies, my lord. Serial number 41, interim order may kindly be extended.
Don't extend the interim order. ಕೇಳಿಸ್ಕೊಳ್ಳೋದೇ ಇಲ್ವಾ?
My apologies.
ಮಾಡಿದೆ sir. Don't.
My apologies.
Appear for the petitioner. My lord, the land in question, my lord, was the subject matter of a notification dated 22/5/2008, my lord. And in fact, my lord,
Interim order ಇದೆಯಲ್ಲ ಮೇಡಮ್?
my lord, covered by
Jaykumar,
judgment.
covered ಆ?
It's covered by the judgment. my lord,
bench of
which
the
ಯಾವ್ದು ಇದು?
NPK layout. NPK layout, madam.
ಇಲ್ಲಿ
My lord,
annexure it will close it then.
It has to be decided in accordance with that only.
ಆಯ್ತು.
my lord, if your lordship could see, my lord,
ಅಲ್ಲ, if it is covered, we'll close it according to that.
my lord, in fact, my lord, a submission was made, my lord, by the council for the BDA. Kindly come to page 57, my lord. In page 57.
57.
Yes, my lord. My lord, it's annexure K, my lord. Annexure K. My lord, earlier, my lord, the notification was called into question. When that case, my lord, the notification which was acquired, my lord, was called into question. A submission was made, my lord, by the senior counsel, my lord, which is extracted in serial number, page 57, my lord, in page 57. It's now submitted by the learned counsel so-and-so, appearing on behalf of the learned counsel for BDA, that after a detailed survey, it has been ascertained that the land involved in this petition consists of a well-developed nursery, and therefore, the BDA has recommended that the same be deleted from the acquisition proceedings. It is therefore now for the state government to expedite consideration and pass an appropriate order.
This is what concerning the same petitioner?
Yes, my lord. Same petitioner. And then, my lord, they wrote to the annexure L, my lord, is a letter, my lord, which has been.
But there is a change in law by the division bench.
Please, the
My lord-
parameters are now been fixed by the division bench. Hence why I was submission.
My lord, in fact, my lord, if your lordship could see.
No,
the-
there is change in law with the division bench. Interim order ಇದೆ ಇರ್ಲಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಹೋಯ್ತಿದು.
Yes.
I am the author of that order. Division
You-
bench order.
Yes. Maybe.
ಅದೇ ಅಲ್ವಾ?
NPK layout.
My lord, this is, my lord.
No, there is one ನರ್ಸರಿನ ಬಿಡಬಾರ್ದು ಅಂತ.
Please. Shriram Karat layout.
Yes.
My lord, in fact, my lord, it's not only nursery, my lord. There are other.
No, I have laid down parameters as to what should be construed as a nursery to drop it from acquisition.
Yes.
But there is already an order in your favor earlier.
Yes, my lord.
Inter partes it has become final. So we will protect you by an interim order. To
In
the
fact, my lord, in fact, in similar circumstances, the honorable court, my lord, in annexure Q, my lord, has
Correct.
passed an order.
Yes, Krishna Kumar ಅವರು.
Yes, my lord.
ಅದು ಹಳೇದಾಗೋಯ್ತು.
Here.
Mine is 2025
I'll just look into that and make.
and Supreme Court has not interfered.
Oh.
It's a detailed order.
I'll.
I will post it after vacation.
Yes.
Please.
List the matter after vacation. Interim order subsisting will continue to the next date of hearing.
44.
My lord, challenging the 39 rule 1 and 2, which is been rejected by appellate court. The execution court had dismissed the 39 rule 1 and 2 filed by respondent 1 and 3 who are also DHRs in them. ನಂಗೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ, ಕನ್ವೆನ್ಸ್ ಬಂದಿಲ್ಲ.
ಏನಾಗಿಲ್ಲ?
Also sailing with me.
Sailing with you.
ಹೌದು. My father.
What is that under challenge? Tell me.
Rejection of 39 rule 1 and 2.
By the first appellate court.
First appellate.
What happened before the
execution court had dismissed that
concurrent finding?
Divergent finding.
ಈಗೇನ್ ಕೇಳಿದಿರಾ ಇಲ್ಲಿ?
ಅದನ್ನ ಚಾಲೆಂಜಿಂಗ್ ದ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರಲ್ಲ,
ಅವರು DHR ಸ್ವಾಮಿ. They are the first wife children. I'm the second wife children. We both are DHRs in the execution.
Let it come on 8th October. List the matter on 8th October. Yes, next.
45 entry.
Respondent number 176, my lord.
Just after vacation. IO.
Entry matter be.
IO. Yes.
46.
Oh, this is that complex.
Koramangala and Indiranagar. But both are commercially. Sadashivanagar matter.
Sadashivanagar ಇದಕ್ಕೂ ಬೇಡ ಅಂದ್ರಲ್ಲ.
No, your lordship said you would consider yesterday, I mean now listed today, whether to combine all the matters together and extend the status quo here also. But Sadashivanagar is a completely different.
ಅಲ್ಲ ಇದ್ರದ್ದೇನ್ ಹೇಳಿ?
Sadashivanagar.
If you want an interim order, you tell me.
In Indiranagar, one fact, before we go.
Because this is at KT CAT place.
In fact, our objections are also ready. In Indiranagar, there are two plots next to each other. Both the plots are now combined and sought to be redeveloped. In respect of one plot, the RMP, which is still valid, says it is for public use only. And public use cannot be for commercial use. The building where the CAT is located, that, my lords, even according to the master plan, there is commercial use. So we don't have any challenge with that. But there are two challenges we are making. One, the process of making a redevelopment scheme in our respectful submission has not been followed. Second, by combining a plot which is for public use only, and public use is very clearly mentioned in the RMP as to what can be used, what is public use. Public use is certainly not commercial use. There's a list of activities and manner of construction, what it can be used for, specifically listed in the RMP. When that is the case, if it is sought to be used for something else that is neither mentioned in the RMP nor under any scheme that has been approved in accordance with the KTCP Act, there has to be a status quo.
Yes.
The same ground.
There has to be a status quo.
Well, status quo
will
is
grant.
not,
Yes.
Because we are dealing with Sadashivanagar.
No. This matter, if it is public use, how are you giving it for this?
That's a simple question, as far as Indiranagar is concerned. In Koramangala, it is civic amenity site.
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. Civic amenity site. Sadashivanagar and Koramangala is civic amenity sites. Indiranagar, half of it is public use. Half of it, we are not questioning what it can be used for, but the process we are questioning. Public use iradna kotbittu, they are saying, go ahead.
It is commercially, this one, even in the RMP, much prior to RMP, blood, even in the.
ಆಯ್ತು, objections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕ್ಬೇಕು.
One submission, so far as.
No, sir. ನೀವು ಯಾರಿಗ?
Lord, I have the successful bidder, Lord, who has got the.
Beneficiary.
Yes, Lord. In your lordship, can you see, I have spent about 50 crores already, Lord, on the project.
We'll see.
Lord, may I make one request? Now, Lord, insofar as present status is concerned, Lord, your lordship had also had observed on the last date, the building needs to be demolished. All the tenants have vacated excepting 2. I don't even have a sanction plan as of now. So, Lord, therefore, there is nothing going to happen, Lord, now that I have filed my objections are also ready, Lord, I'll file it in the counter.
No. We'll see. No, if it is meant for public use, now it is going to be for a private use.
No,
None of the matters, both the areas, Lord, even Koramangala and the Indiranagar are always, Lord, even in the 2015 master plan, it is for commercial purpose.
You file whatever you want to file.
RMP map is very clear. I've attached it.
Insofar as Lord, Koramangala is concerned, Lord, I'm not concerned. I'm only concerned with.
Who is Koramangala? No, but anyway. ಅದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆಯಾ?
Koramangala, we had not pressed for status quo.
ಇದರಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ.
In Indiranagar, my lord.
Don't precipitate till the next date.
All that we are doing, Lord, is insofar as demolition, not Construction I can understand. but there's no
demolish
plan
ಮಾಡ್ಲಿ
sanction.
ಅಲ್ಲ demolition ಮಾಡ್ಲಿ
But I
construction
don't even have a
ಮಾಡಬಾರ್ದು.
sanction plan.
That I will do.
But your lordship, there's no necessity for an order, my lord, because obviously it will take time, my lord, for us to demolish. and then
Don't worry, sir.
Lord,
Why are you
may I
wait?
point out one thing?
But I-
Lords, may kindly see the.
Sir, you demolish, no problem. Demolition ಅವ್ರೇನಿಲ್ಲ. Don't begin construction.
Obviously not, I cannot because I don't even have. a
ಆಯ್ತು, we'll
sanction.
hear it, yes.
Lords, may kindly.
Cause not, I cannot obviously demolish the building within the next 2 weeks. my lord, and
Already
start
they are claiming
construction.
equity
So
for spending money and demolition.
But I may just,
ಅದನ್ನ
I have
ಇನ್ನ
serious
equity
objections to
claim
this
ಮಾಡ್ತಾರೆ.
maintenance.
You
of this
file,
petition.
ಅದು ಆಯ್ತು, we'll see, you file everything.
Kindly
sir.
see the delay, my lord, in 2018 agreement. are
ಆಯ್ತು,
changing now.
ನಾವು ಪ್ರೊಸೀಡಿಂಗ್ ಕಮೆನ್ಸ್ಮೆಂಟ್ ಡೆಮಾಲಿಷನ್ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರಿ?
Demolition should start now.
ಅದಕ್ಕೆ ಈಗ
But
ಬಂದಿರೋದು.
the whole basis is the very agreement.
ಆಯ್ತು, we'll hear it. I'm not saying we are going to.
That was in 2024.
Going to set aside ಅವೆಲ್ಲ ಇಲ್ಲ. Let me hear it.
There's no difficulty in lordship hearing, not obviously I cannot. I may also point out one aspect, Lord, their contention. In fact, the BDA at the time of tendering itself has clarified, it's a mutation corridor. Mutation corridor, not all uses are permissible.
ಈಗ ನೀವು ಡೆಮಾಲಿಷನ್ ಈಗ 2 weeks 3 weeks ಬೇಕಾ ಡೆಮಾಲಿಷನ್ಗೆ?
More than.
Then you let the demolition go on.
There's no necessity for any interim order.
Sir, you raise the building to the ground which has to be demolished, not a problem. We will hear it further later, yes, and then we'll pass out.
Absolutely.
Whether you should be permitted to construct or
That's a
not.
different matter, not your lordship may have it not after vacation. your
I
lordship
will
may-
have it after vacation, definitely. Heard Dilan? ನಿಮ್ದೇನು sir?
One objection with regard to Kormangla I want to take. Lord, this is a commercial area which is demarcated. Lords, may kindly see the cost title of the petitioner. Lord, they say they are the Residents Welfare
Correct.
Association, have registered their office in the park, first instance. Lords,
Inside
may-
the park.
Inside the park, that's an address given. Lords,
Who's
may kindly
appearing
say,
for Kormangla?
Why have they come?
I am
I'll
instructed
just point
Kormangla
out. I'll just point out as to why they have come. This honorable court, while dismissing the writ petition of the tenants, say that it has to be commercially exploited for the
Right, we'll
purpose of the
consider that
benefit of
also,
this, all
Puri.
this. They have come now
Give it,
without
sir.
disclosing anything.
Give it, we'll see. You file your objections,
Yes,
Murugesh.
I'll do that.
That is also not the kind of grounds they have
As
raised.
for
Right, we'll answer everything.
I'm not only saying that there's no requirement for any.
No, you demolition, you do it
May I just submit this? I appear for the successful tender
in Kormangla.
in Kormangla.
Ah.
May I just submit this? Monies are being spent to pay the licensees to vacate the property and then demolish the building blocks.
That you move with that, sir, but you shall not begin construction.
They are interconnected. I'm spending crores of rupees to have them vacated. Now, my lords, I spend the money, my lords, and I am not permitted to put up the construction.
ಏನ್ ನಾಳೆ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಸರ್? Yes, sir.
Demolition.
Ah.
Today, my lords, they are asking for a stay of the against construction. I understand. And the project cost is 180 crores. Now, my lords, there's an increase in the cost of construction by every.
No, I
day.
want to see if it is in a civic community site and
Civic
it is
community.
given to, that's all, the examination ಅಷ್ಟೇನೆ. We will hear, ಈಗ ನೀವು demolish ಮಾಡಕ್ ಯಾರು ತೊಂದ್ರೆ ಕೊಡ್ತಾ ಇಲ್ಲ. ಮಾಡಿ.
Let the petitioner be put on notice, my lords, that any increase in the cost of construction, they'll be responsible for it. They are a bunch of people, my lords, who have got the registered office in the park, trying to come in the way of a project, my lords, which is being done on a commercial site. We will stop the construction, my lords, as your lordship says.
You have not started the construction, sir.
they have not even started demolition,
Hey.
not even started demolition in Kormangla.
1 minute, will protect you adequately, wait. Ada, next time when I extend the interim order, if I say you don't construct, then we'll put them on terms. All right, till then you demolish. Heard the learned senior counsel Harsh Narsappa, that's correct, right? Harish Narsappa. Harish Narsappa appearing for the petitioner and the learned senior counsel, Shri, ಅದು ಗೊತ್ತು ಇನ್ಯಾರಿದ್ದಾರೆ ನೋಡ್ತಾ ಯಾರಿಗೆ ಶ್ರೀನಿವಾಸ ರಾಘವನ್ for the sixth respondent and the other counsel so and so. The issue in the list is with regard to a property being constructed allegedly on a site that is for public use in so far as the Indranagar area is concerned.
Partly for public.
Partly for public use in so far as the Indranagar area is concerned, and on a civic community site allegedly in so far as the Kormangla area is concerned. In both these cases, the successful tenderers are the respondents. The successful tenderers would submit that they have spent huge amounts of money and have begun demolition of the property or would begin demolition of the property. Therefore, the demolition of the property would not mean beginning of construction of the property. In that light, I deem it appropriate to direct or permit the respondents to demolish the property demolish the property and prepare it for the purpose of construction of the property by raising the structure to the ground, which is which is to be demolished. Insofar as the beginning of construction is concerned, as it would not happen in the next fortnight or 2 fortnights, as the case would be, without the leave of the court, construction would not commence. Objections or all other pleadings be completed by the next date. List the matter on 31st October at 3:30 PM
Have
for
it
the
on
hearing.
23rd because the other.
ಯಾವತ್ತಿದೆ ಅದು?
In 23rd October. Sadashiv Nagar is on
23rd October.
Sadashiv is on
ಅಲ್ಲ ಅದಕ್ಕೆ ಇದಕ್ಕೂ ಬೇಡ, ಅದ್ ನೋಡೋಣ ಆಮೇಲೆ.
Very well, Manoj.
List the
Issues
ma-
are the same.
ನೀವು ಮುಗಿಸಿ ಸರ್ ಡೆಮಾಲಿಷನ್. In the event the demolition would get concluded within the next date of hearing, liberty is reserved to the respondents to move the matter.
Please.
Yes. List the matter on 31st for further hearing at 3:30 PM. It will be on 31st. You move it, we'll take it. Yes.
47.
Lord, this is a matter your lordship was pleased to hear me on the last date of hearing. A petition for restoration of the suit, my lord, for partition, which came to be dismissed for default, whether it is permissible, my lord, for the defendants to move an application for restoration. My lord, defendants 4 to 8.
Who has moved it for restoration?
Defendants 4 to 8.
Defendants 4 to 8.
In a suit for partition.
Suit for what?
Suit for partition. They
Dismissed
moved
for non-prosecution ಆಗಿತ್ತಾ?
It was dismissed for non-prosecution. Plaintiff
Who
there
filed
is-
miscellaneous application?
Defendants 4 to 8 filed a miscellaneous application to get the suit restored. Both the courts, my lord, both the original court, my lord, as well as the appellate court hold that it is only the plaintiff who has got power to get the suit restored. And the defendants, my lord, cannot move an application. And
You are who?
I am the defendant.
You are the one who filed the application.
I am the one who filed the petition for restoration of the
For
suit.
restoration of the suit. That is rejected.
That is rejected only on the ground that the defendants cannot file an application and
ಅದೇ
only the
ground,
plaintiff can file an application.
All right, yes. Anything else, sir?
In this case,
In a partition suit, defendant plaintiff is illusory. ಯಾರ್ ಬೇಕಾರ್ ಹಾಕ್ಬೋದು. Anything else?
our written statement ಹಾಕಿಲ್ಲ.
ಯಾರು?
Our written statement ಹಾಕಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, so what? That doesn't mean suit can recall, we are concerned with the recalling application.
No, my lord, 2013 they were served. They were aware of it. They did not file it in time. They have filed it after 10 years, my lord.
ಏನು?
ಹೌದು.
ಅಪ್ಲಿಕೇಶನ್ 10 years ಆದ್ಮೇಲೆ ಹಾಕಿದೆ.
ಇಲ್ಲ.
Recalling application dismiss ಆಗಿದೆ ಯಾವತ್ತು?
The suit was dismissed on 12/3/2019.
And miscellaneous petition, my lord, is filed during the year 2021.
And they were aware of the suit.
ಪರವಾಗಿಲ್ಲ, COVID ಇತ್ತು.
ಅಲ್ಲ, suit summons were served in 2013, my lord. 2013 ನಲ್ಲಿ summons serve ಆಗಿದೆ. They were aware of the suit. They didn't file any application. They didn't file the written statement. Now how can they seek for restoration, my lord?
ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, I filed an application under Order 7, Order 7 Rule 11 for rejection of the
ಈಗೇನು ಇಂಟರ್ಮೋಟರ್ ಆಗಿರೋದೇನು?
ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ ಈ
Court fee ಕಟ್ಟಿಲ್ಲ.
ಡಿಫಾಲ್ಟ್ ಆದ್ಮೇಲೆ
converted land court fee ಕಟ್ಟಿಲ್ಲ.
ಈ ಕೋರ್ಟ್ ಫೀ ಇದು
And I've got an industrial building there sold by them.
We'll hear it after vacation. The learned counsel for the petitioner is the petitioner is the defendant in all these cases. He is before the court on the score that the concerned court rejects the application, concerned courts rejects the application of the petitioner filed seeking recalling of a suit that is dismissed for non-prosecution. According to both the courts, the learned counsel would submit that the application ought to have been preferred only by the plaintiff and not by the defendant. They said prima facie, they said observation to reject the application is erroneous, as in a partition suit, the rank of the parties either of the distinction of the parties as plaintiff or the defendant is illusory, as it is division of the joint family property which would devolve to all the parties to the list. In that light, the learned counsel for the respondent would, however, dispute the position on the merit of on the facts obtaining in the case at hand. Therefore, the matter requires consideration. Lest the matter after vacation, interim order subsisting will continue to the next date of hearing.
suit ಹಾಕಿದ್ದಾರೆ. ಇನ್ನ ಎರಡು suit
ಅದು ಗೊತ್ತಿಲ್ಲ, ನೋಡೋಣ ಆಮೇಲೆ. Yes, next.
OS 28 of 20 ಹಾಕಿದ್ದಾರೆ.
Next.
So for us, my lords, the remaining amount to be paid in pursuance of a decree, my lords, there are dispute.
Pay ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು ಮಾಡಿದೀವಿ. In fact, to satisfy, they said they'll settle it if another 50,000 is paid. That is also paid
That's
today.
paid today.
We'll close it then.
Please.
That can be.
The petitioner is before this court seeking the following. Owing to the submissions made by the counsel for the petitioner, this court on 20th August 2025 had passed the following order. The learned counsel for the petitioner, MP Srikanth, would submit that the counsel for the respondent had submitted that if another 50,000 is paid, it would suffice and the matter could be closed, which is also paid during the subsistence of the petition. In that light, the counsels would submit that the matter be closed, setting aside the order. The order be set aside and the matter be treated as closed between the parties. Therefore, in the light of such submission, I deem it appropriate to pass the following order. Allowed, quashed. In the light of the compliance as observed herein above, the matter stands closed between the parties, which would close between the parties on all counts, ordered accordingly.
Execution
also-
proceedings are to be.
Both, there's also one more writ petition if both
That
parties
has
will
infraction. That has
withdraw
become
it.
Which is that writ petition?
Uh,
Pending idea?
Pending the 2023 order was challenged.
Writ
That-
petition number
number ಹೇಳಿ.
15480.
Number code.
My lords, writ
ಅದು
petition number
disposed.
15480
Will
2023.
post it and dispose.
Please,
Next.
we have to move for
59.
order of execution proceedings. ಅದಕ್ಕೊಂದು
ಅಲ್ಲ ಕ್ವಾಶ್ ಮಾಡದ್ನಲ್ಲ ಅದು. The entire proceedings in execution stands quashed.
please.
Petitioners, I state this, you court told to file objection or kill us.
2 weeks time. ಇಲ್ಲ ಯಾರು ಇಲ್ಲ.
The only thing is that 151
Milords,
application.
I'm
filed by
sorry,
the-
Milords. I appear for the respondents. I apologize for appearing on VC, Milords.
Hey,
I'm
that's
not
okay, sir.
keeping well.
Yes, tell me. No problem. Yes.
Milords, we were to file objections, Milords. There is some difficulty. Your Lordships may grant us 1 week additional time. We'll file it.
Only
9th October.
Only concern
Please,
is that.
please, we'll file.
Some third party ಬಂದು alienate ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತೀರಾ some property.
Milords, it's a suit for injunction that he has filed. There is no.
Yes, no, yes, next.
Please,
Right.
please.
Petitioner in this case, the RFA is posted for reserve for orders, my lord. Kindly have it on authorization.
ಆರ್ಡರ್ ಮುಂಚೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಆ ಥರ. ಏನ್ RF ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
The RFA is pending before the honorable second court.
List after, at the request of the council appearing for the petition, list after 4 weeks. Next.
51.
In this matter, Lordship.
I filed Wakala,
The objector's petition, Lordship.
7th respondent. For the respondent in this matter. In fact,
Yes, sir.
Yes, Lordship. The suit for eviction, the which filed by the respondent number, the 1 to 6 against the respondent number 7 before the trial court, Lordship, it came to be a decree, Lordship. Thereafter, Lordship, by virtue of the decree, the respondent number 1 to 6 and filed an execution petition before the trial court, Lordship. Where, Lordship, they are in, I am the tenant of the first floor, Lordship. They are not made me as a party in the proceedings as well as the OAS as well as the execution proceedings, Lordship. For that, Lordship, I incline to file the interim application number 2 for
Under
an for
2197 application.
Yes, Lordship. For objector application.
File an appeal, sir. It's rejected now?
No, Lordship, it's not being considered.
Will direct consideration.
Yes, Lordship. Meanwhile,
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
may-
ಆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ ಮಾಡ್ಲಿ object,
Please,
may
Lordship.
put it across, man. They have filed a objector application. It is pending before the court. Trial has been, inquiry has been conducted. Trial is going on. Now, in so far as I have not come in the way of their objector application, let it be disposed on merits. But now, in their objector application, they have said, we are the tenants. And that is.
Let that be decided by the court.
Let that be decided. In fact, that issue has been decided in the judgment in the trial court as well as before this.
I'll argue ಮಾಡಿ ಎಲ್ಲ all your contentions put forth in that I will direct the court to consider in accordance
If
with
he
law.
says, I have not been paid the rent from the 2008.
You judgment ಕೊಡಿ ಕೋರ್ಟ್ದು.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿರೋದು 10 ಲಕ್ಷ ಕೊಡಿ ಅಂತ.
ಅದ್ರ ಮೇಲೆ ಬಂದಿರೋದು.
10 ಲಕ್ಷ ಕೊಡಿ, 2008 they have not paid. And every time they
ಅದು
keep
ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? Yes, sir.
yes, Lordship. Meanwhile, they prefer to file an application under proviso of section 151 for recovery of the rent amount. I have of rupees 10,10,000 rupees. For that, Lordship, the court has been passed in the impugned order, Lordship. Please comes to ink page number 22, Lordship.
Yes, sir. Coming. ಹೇಳಿ sir.
Yes, Lordship. Sorry.
ಹೇಳಿ sir.
The IA filed by the applicant DHR under section 151 of the CPC is partly allowed, whereby the objector is directed to deposit arrears of the rent about 5,000 rupees per month from April 2013 till the date within 3 months from the date of this order, and also tender himself for the cross examination by 26th, so on so lordship. The trial court was directed me to deposit the arrears of the rent by calculating the 5,000 rupees since 2013 lordship. Lordship, even though the some stray admissions which the made by in affidavit of my application lordship, till it's not been considered lordship, unless and until the trial court is decided of my application lordship, and directly comes to the IA number 9 and they allowed and directed me to deposit amount lordship. The proposition of law is this lordship.
Position of law. Yes sir.
The proviso of section 53 of the Limitation Act is this lordship. There isn't 3 years for time bond to let them recovery of the due rent amount from my end lordship, till they are not made any attempt against me lordship, till no case is being filed against me lordship. And when I try to attempt before the trial court lordship, they're inclined to file an application and got the order lordship. And lordship, please come appreciate me lordship, for
Appreciate
application
it.
also, for filing of the application also lordship, where the grave letters of the they are not following the civil rules of practice, particularly on rule 70 lordship. They are not mentioned the full cause title lordship. It may be remanded back to trial court lordship. We will contest the matter for the both application lordship. Let the trial court decided on the both application lordship. The first IA number 2 lordship, thereafter IA number 9 lordship.
ಆಮೇಲೆ
That is
Yes,
my
sir.
respectful submission lordship.
ಹೇಳಿ sir.
Or in fact, the judgment in the.
Earlier judgment ತೋರಿಸಿ sir ಯಾವ್ದು.
Lord, I have also failed to furnish the judgment.
Failed
Lord.
filed
Failed to furnish the judgment before the.
failed to furnish. ಆಯ್ತು. When will you file to furnish? ನಾಳೆ ತಗೊಳ್ಳ
Please, ma'am.
ಅಥವಾ 8ನೇ ತಾರೀಕು ತಗೊಳ್ಳ?
ನಾಳೆನೇ ತಗೊಂಬಿಡಿ sir.
ನಾಳೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಆಯ್ತು.
Please, ma'am.
Please lord.
ನಾಳೆ. Don't fail to furnish tomorrow.
Definitely.
Yes. List tomorrow.
The interim
Intermodal subsisting will continue till the next date.
Great lord.
52.
I'm appearing for the appellants, Your Honor. The copy is already served to the other side.
Yes sir.
Your Honor, this is an execution petition filed before the
serial number madam?
commercial court.
52.
Commercial court.
Yes sir.
The execution court added appellant number 2 to 6 in the execution petition, Your Honor. So 2 to 6 are not signatory to any arbitration agreement, anything like that. So there is a Supreme Court ruling recently which says, non-signatory to the arbitration agreement cannot be made as a party. So
Now what's the problem?
now
ಈಗ allow ಮಾಡಿದಾರಾ?
allow ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ they are coming to my premises, 2 to 6 premises ಬಂದು.
Yes sir.
My lords, if I may, my lords, I'll inform about the background of the present case, my lords. It's an execution proceedings, my lords, filed as against the arbitration award. It was an ex parte arbitration award. They failed to participate in the arbitration award. Under the guise of challenging the arbitration award, they filed the present petition, my lords. Point number
34.
one. They've utterly failed.
Time is over.
Time is barred, my lords, beyond 3 months, beyond in fact almost 10 years, my lords, lapse of 10 years. Subsequently, my lords, they partially fulfill the decree, my lords. First time when there's an attachment proceedings, they partially pay the amount. Subsequently, in view to cause difficulty to the decree holder, my lords, they change the name of the company. That name change, there's an amendment application that came to be filed before the execution court. That came to be allowed, my lords. That's the only point of contention, my lords.
In fact, Your Honor,
But
this,
if I may
You are
point
the
out an
judgment
issue-
debtor.
I'm a judgment debtor. The name change has been disallowed by the execution court earlier. Now, again, after 495 days, they file another application to allow initially it was rejected by the execution court. Now, what they're supposed to do is they should come before the high court and get it restored, that order. Instead of doing that, they go back again to the court and they file an.
Where is the impugned order?
Page number. Now kindly see page number 223, Your Honor.
223.
Annexure W.
Yes sir.
Initially IA 7 was rejected. Page number 161 is there, Your Honor. IA 7. So
The IA11 amendment of JDR company is allowed. His company.
My lords, in fact, he is the judgment debtor, my lords. If I may explain the facts, my lords.
Now, according to the Supreme Court, Your Honor, no.
You are
parties
not a
can be-
third party, sir. Don't worry. Yes.
Yes, I'm not a signatory, in fact.
No problem, sir. ಆ ತರ ಬಿಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ನೇಮ್ ಚೇಂಜ್ ಮಾಡಿ will defeat the
No, no,
award itself.
My name got changed, before the execution itself. In 2020.
Anything else, sir?
Your Honor, initially, IA number 7 came to be rejected of the transferring company. Now, what they supposed to do is they should have come to the High Court and
So
get
don't
it
worry
restored.
about that, sir.
ಅದು ಮಾಡ್ತಾರೆ ಏನ್ ಮಾಡ್ತಾರೆ again.
Now I will do it. No problem.
So this is what my grievance is. Your
No,
Honor.
no grievance.
If
Yes,
I may,
anything
my
else?
No, this is the only main contention, Your Honor, because I'm
We'll-
not the party and.
We'll dismiss it.
According
ಈಗ
to.
ಸ್ವಲ್ಪ history ಹೇಳಿ.
My lords, if I may, my lords, they filed 12 applications, my lords, to delay my
ಅದೇ
execution.
history ಹೇಳಿ
My
ಅಂದ್ರೆ
lords,
12
in fact,
applications. Yes.
my lords, I have filed an execution petition in 2020, my lords, that subsequently they come on record. They file multiple applications, they file objections. In fact, time and again, the honorable
What
court.
is the date of the decrease?
My lords, 2016.
Sorry, what is the date of the award?
My lords, 2016, my lords,
2016. Execution ಹಾಕಿದ್ದು.
2021.
What was who was the judgment debtor? Who was the signatory to the arbitration earlier?
My lords, the
There's
company-
nobody signed
Wait,
the
sir.
arbitration agreement, Your Honor.
Which company?
My lords, the judgment debtor company, my lords.
Tree Walker.
Tree Walker.
ಅವರೇನಾ?
Area 1.
Area 1.
Sorry, upland 1, according to them, upland 1 has signed the.
No problem.
Arbitration
Well,
agreement.
if you keep 1 minute, if you're there.
Yes, Your Honor. Yes, Your Honor.
Yes.
Subsequently, my lords, I've been represented by managing director and directors of the company, my lords. That's the plea taken. Subsequently, once I go for second attachment, my lords, second round of attachment, they conveniently change the name to Tree Walker Technology India Private Limited. In view of that, my attachment is defeated on that purpose, my lords. Subsequently, I carry out necessary amendments, producing all the documents, incorporation certificate and GST registration reflecting the changes in the name. Even in the MCA portal, there's name change reflected. It's not an entity that's changed. The change of name has been reflected. Based on that, I filed an application, my lords. That application came to be allowed in the year 2024, March 19/3/2024. That application has been allowed. Even after that, my lords, they failed to repay the amounts. Second round of attachment goes, I've attached certain property, valuation has been done with respect to the property, my lords. Then they go ahead and file this present petition. In fact, they file multiple rounds of application before the trial court also, my lords. The entire purpose of execution petition has been defeated by filing multiple rounds of applications, my lords, because the court is not even going ahead with attachment in view of the applications that have been filed.
My lords, I was not got the arbitration notice at all. Without, behind my back, the arbitration was conducted.
You should have challenged it.
No, it was, this came to be
34,
executed in 21. No.
34. You should have gone on 34. You have lost 34 limitations. So this petition.
No, in fact.
The petitioner is the judgment debtor. He is at the doors of this court calling in question an order of the executing court dated 19/3/2024 by which the amendment of the name of the judgment debtor company filed by the decree holder comes to be allowed. The heard so and so. The history of the case dates back to April 2013, when the respondent is claimed to have approached the first appellant to develop a mobile application called Hotel Life. The dispute between the two arose and for the resolution of the dispute, the parties resort to arbitration. An arbitral award comes to be passed on what date? Date Selbach.
4/3/2016, my lords.
On 4/3/2016. The arbitral award is not challenged by the judgment debtor. Time pass, challenge ಮಾಡಿದ್ರಾ?
Challenge ಮಾಡಿದ್ವಿ, ಸ್ವಾಮಿ.
Was not challenged by the judgment debtor. Time passes by. Therefore,
it was challenged. They did not accept my notice.
Therefore, the respondent decree holder seeks to execute the award of the arbitrator by filing an execution petition before the concerned court in the year 2021. Since 2021, it transpires that the execution proceedings are dragged on one score or the other by the judgment debtor by filing multiple applications. Be that as it may, what drives the judgment debtor to this court at this juncture is the impugned order. The impugned order is a product of an application filed by the respondent decree holder to bring in the change of the name of the company, not the entity. The concerned court allows the application on the score that the change of the name of the company was necessary, as all the documents of such change was placed by the judgment debtor before the concerned, before it for an order to be passed, which is now impugned in the subject petition. The learned counsel appearing for the decree holder submits that the apex court in its recent judgment, learned counsel for the judgment debtor submits that the apex court in the recent judgment holds that a non-signatory to the arbitration cannot be drawn into the execution proceedings, and therefore the order is bad in law. Barring this, he has no other submission to make on the issue that is projected before the court. The learned counsel for the respondent contrariwise, the learned counsel appearing for the respondent submits that the judgment debtor is wanting to evade the execution of the proceedings, as the executing court the proceedings before the executing court is now 4 years old. It is dragged ad nauseum by filing plethora of applications. The learned counsel submits that the name of the company is changed and not the entity, and what the application projected was only the name of the company, and the present petition is preferred after 1 year of the order that is passed on 1/3/2024 permitting the change of the company only to drag the proceedings. I have given my so-and-so. Before considering the issue on its merit, I deem it appropriate to notice what the apex court has held in the case of Rahul Shah versus so-and-so. The apex court lays down postulates for disposal of the execution proceedings, which holding that it should be 6 months or at best 1 year. The execution proceedings to execute an arbitral award of the year 2016 is still pending in the year 2025. We would only show an appalling situation. The reason ostensibly is filing of plethora of applications by the judgment debtor, and when all the applications fail, come up with the subject novel idea of change of the name of the company, though the learned counsel for the petitioner judgment debtor submits that the change of the name of the company comes about during the pendency of the proceedings itself. Be that as it may, the change of the name of the company is what what was prayed in the application filed by the decree holder. The concerned court allows the application by the following order, which where is the impugn order?
223, my lords, page number.
$223,
223, my lords. That's, I don't have the complete copy of the petition, my lords. In fact,
petition paralla. Elide 223
page number 223.
The order reads as follows. Though the order does not contain any reason to do so, it need not contain any reason to do so, as it was only a change of the name of the company and not the entity. The judgment debtor is now still wanting to defeat the proceedings, defeat the closure of the execution by filing the subject petition and seeking an interim order of stay. Therefore, it is a case where the petition deserves to be dismissed. Adun Kodi judgment. The reliance placed upon the judgment of the apex court in the aforesaid case is distinguishable without much ado, as in the case at hand, it is not new impleading applicants are brought into the execution proceedings by the decree holder, but it is only change of name. The petitioner is the signatory to the arbitration agreement.
I'm not the signatory. I'm not the signatory.
The erstwhile name of the present petitioner is the signatory to the arbitration proceedings. It is not the change of entity or taking over of the entity by someone else. It is only a change of name. Therefore, the said judgment that the learned counsel for the petitioner seeks to place reliance upon would not become applicable to the facts of the case at hand. Therefore, the case at hand becomes one that ought to meet its dismissal, not dismissal simpliciter, but with imposition of exemplary costs of rupees 50,000 for having wanting to stall the execution by filing the subject petition seeking an interim order. For the aforesaid reasons, the following order: petition is dismissed with exemplary cost of rupees 50,000 to be paid by the petitioner to the respondent. Next. Next.
Respondent number 16 in this case.
Is a suit filed for easement of.
ಮೈಕ್ ಹತ್ರ ಹೋಗಿ ಯಾಕೆ? ಹಾ.
Suit was filed on the basis of easement of necessity.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ,
Amendment ಇತ್ತು.
But there
Now
was an
there's a
amendment.
fresh
ಮೀಡಿಯೇಷನ್ ಕರೆಕ್ಟ್ ಏನಾಯ್ತು?
fresh road form ಆಗಿದೆ.
ಅಲ್ಲ ಮೀಡಿಯೇಷನ್ಗೆ ಹೋಗ್ತೇವೆ ಅಂದ್ರಲ್ಲ.
ನಾವು ಹೋಗಿದ್ವಿ. There is a fresh road. KDB has.
Blood, that particular road, what he is saying is not helping. In fact, what the respondent number 1, they are claiming to be some road that is existing previously prior to formation of the KDB layout. After the layout is formed, that road is not existing. They are previously when they filed the suit, they sought that existing road to be used. But later there is another road that is being formed. Only thing is that what they are seeking, that part of the property comes into other layout actually. So it doesn't form in the part of that particular road. This needs a this needs to be verified, my lord, in the trial court itself.
I think mediation ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇನ್ನೂ ಆಗ್ತಾ ಇದೆ. ಆಯ್ತಾ?
ಆಯ್ತು ಸ್ವಾಮಿ. There was two.
Road ಇದೆ.
What happened?
ರೋಡ್ ಇದೆ ಅಂತ ಪ್ಲೇಂಟಿವ್ಸ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಡಿಫೆಂಡೆಂಟ್ಸ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, KDB ಒಪ್ಕೋತಾ ಇಲ್ಲ. ಅವರೇ ಮಾಡಿರೋ ರೋಡ್
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಷ್ಟೇ. That is what
themselves have farmed the road.
ಅವರೇ ಮಾಡಿರೋ.
They only have to bypass certain things and to take advantage of it.
We could have given the quietus to the entire suit 2012 matter. And it is not, I mean.
Maybe decided by the trial court itself.
List on 8th October.
Or minutes if. Let
8th October.
If there's a direction to the trial court to dispose of the suit in 3 months.
ಅದೇ ಹೇಳ್ತೀನಿ ಈಗಲೇ ಬೇಕು.
ಅದ್ ಮಾಡ್ಬೋದು.
3 months.
The petitioner is before this court seeking.
6 months ಬೇಕಾಗತ್ತೆ.
ಯಾಕೆ ರೋಡ್ ನೋಡ್ಬೇಕಾ?
Comments
ರೋಡ್ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲೆಲ್ಲ ಕಮೆಂಟ್ಸ್ ಆಗ್ಬೇಕಾಗಿದೆ.
ರೋಡ್ ಕಮೆಂಟ್ಸ್ ಆಗ್ಬೇಕಾ?
ಅಲ್ಲ ರೋಡ್ ಅದಿನ್ನು ಸ್ವಲ್ಪ ಉಳ್ಕೊಂಡಿದೆ, ಅದನ್ನ ಅವ್ರೇನು KDB ಅವರು ಹೇಳ್ಬೇಕಾಗತ್ತೆ. Let it be have
3 months is enough to suit for.
Let it be.
It's a suit for easement. Easement.
The petitioner is before this court seeking the following prayer.
Amendment is allowed.
One ನಿಮಿಷ. The following prayer. What drives the petitioner to this court in the subject petition is the allowing of an application filed under Order 6 Rule 17. Order 6 Rule 17 by the respondent. The learned, owing to the submission of the counsels for the parties were referred to mediation by 2 orders passed 1882 in Mikidon. The parties have sought to mediate, but the mediation has not yielded any fruits. The learned counsel for the petitioner now submits that the petitioner and the respondent are agreeable for a settlement with regard to the road, but the KIDB, which is now forming the road, is not accepting the settlement. Therefore, it is in the fitness of things, the learned counsel for the petitioner and the defendant, petitioner and the respondent would submit that if a direction is issued to the concerned court to dispose the petition within a time frame would suffice for the present. In the light of the issue being agitated for the last 13 years and the issue being one of easementary rights, I deem it appropriate to direct the concerned court to dispose the suit with an outer limit of dispose the suit of the year 2012 with an outer limit of 4 months from the date of receipt of the copy of this order, if not earlier, in accordance with law.
Right.
Yes. All contentions of the parties projected before this court shall remain open to be urged before the concerned court.
54.
Please, madam. My lord, petitioner is JDR, my lord. The respondent DHR suit for declaration position is decreed confirmed in RSA. Now, my lord, the demolition is to be done, my lord, measure of my property will go. Therefore, I requested the trial court, my lord, to direct him to sell the property to me. This honorable court also directed both of us to explore the possibility of settlement. My lord, we have offered, my lord, more than the market value. In fact, my lord, before the independent.
More than the market value, my lord, earlier there was negotiation and they have come to the conclusion for 25 lakhs. And it's ultimately, finally, they have not come forward.
I think settle ಮಾಡ್ಕೊಳ್ಳಿ ನಾನು ಕೂತ್ಕೊಂಡು.
They are ready, but they are.
ಅಲ್ಲ, ನನ್ನ ಪ್ರಾರ್ಥನೆ ಇಂಡಿಪೆಂಡೆಂಟ್.
ಅದೇ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ರಲ್ಲ ತಾನೇ.
ಇಂಡಿಪೆಂಡೆಂಟ್ ಇವ್ರ ಮುಂದೆ ಡೀಡ್ ರೈಟರ್ ಮುಂದೆ ಇಬ್ರು ಹೋದ್ರು ಸ್ವಾಮಿ. ಒಂದ್ ನಿಮಿಷ ಲೆಟರ್
ರೈಟರ್ ಹತ್ರ ಹೋದ್ರೆ ಏನಾಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಇಬ್ರು ಯಾಕಂದ್ರೆ ನಾವು ಅಪ್ರೋಚ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ therefore we went there. He was also present. In fact, my lord, your lordship may kindly
you called the deed writer to settle the issue.
No, my lord. Just as a middleman. Because, my lord, they insisted my presence.
You middleman ಬಿಡಿ, I'll refer you to mediation ಏನಾರ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
ಈಗ ನಾನು ಒಂದ್
ಅವ್ರ ಸೈಟ್ ಅಲ್ಲಿ ನೀವು ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
They have encroached my property and
But
they have
I think
enjoying
they
my
ಒಪ್ಕೊಂತಾ
property for
ಇದಾರಲ್ಲ.
20
ಅಲ್ಲ
years.
ಈಗ my lord,
That this proposal was given in the original suit, that would be a different matter. They have attempted in 3 unsuccessful attempt and now after.
no
after
ಈಗ ನಾನು
20 years
ತಪ್ಪು
they are
ಮಾಡಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾನೆ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಹೇಳೋದೇ ಇಲ್ಲ. ನಾನು ಈಗ RSA ನನ್ನ ಎಗನಿಸ್ಟ್ ಆದಾಗ ನಾನು ತಪ್ಪು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಐ ಮೇ ನಾಟ್ ಬಿ ಎನ್ ಆಫೀಸರ್.
ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ರೆ that would.
ಈಗ ಅದಕ್ಕೆ
ಈಗ ಬೆಟರ್ ಲೇಟ್ ದೆನ್ ನೆವರ್ ಏನೋ ಒಂದು ಪ್ರಪೋಸಲ್ ಕೊಡ್ತಾ
ಅಲ್ಲ
ಇದ್ದಾರೆ.
ನಾನು 15 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ಸಕ್ ರೆಡಿ ಇದೀನಿ ಸ್ವಾಮಿ.
ಯಾಕೆ ಮನೆ ವ್ಯಾಲ್ಯೂ ಅಷ್ಟೇನಾ?
ಅಲ್ಲ ಆ ಪೋರ್ಷನ್
ಶೆಡ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮನೆ
ಮನೆ
ದಯವಿಟ್ಟು ಅಷ್ಟೇ ಪ್ರಾರ್ಥನೆ. ಅದು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂನೇ ಸ್ವಾಮಿ.
25
3.5 ಲಕ್ಷ ಇದೆ, 3.5 ಸಾವಿರ ಇದೆ ಚದರಡಿಗಳಿಗೆ.
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ ಸರ್, SR ವ್ಯಾಲ್ಯೂ ನೀವು ಹಾಕಿ.
ಅಲ್ಲಿ SR ವ್ಯಾಲ್ಯೂ ಅಲ್ಲ 10 ಅಲ್ಲ ಸ್ವಾಮಿ, 10.5 ಲಕ್ಷ ಅಲ್ಲಿತ್ತು. ನಾನು 15 ಲಕ್ಷದವರೆಗೂ ಕೊಡ್ತೀನಿ.
25 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರಂತೆ. ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬರ್ಕೊಡೋದಕ್ಕೆ ಮುಂದೆ ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ ಈಗ ಎಷ್ಟಿದೆ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ?
Market value, as per my instructions, the parties said that 25 lakhs rupees they are ready to settle it. If they are ready to.
The issue, go to mediation. I will not quote any figure here. The issue in the list is with regard to construction of a property by the petitioner in the site belonging to the respondent.
By encroaching, not full.
Not in full, but in part. Therefore, it becomes a case of encroachment. The petitioner has lost before every fora, but is now wanting to protect the house that he has constructed by striking a settlement with the respondent, and would submit that if the matter is referred to mediation, the quantum that would suffice for a settlement could be arrived at before the mediator. In that light, I deem it appropriate to refer the parties to mediation for mediation in so and so mediation center. The party shall appear before the mediator on the 8th of October at 3 p.m. List the matter on 15th of October. Interim order of any kind subsisting would continue till the next date of hearing, only for the purpose of enabling the parties to settle the dispute. Yes.
My lord, I am also indebted highly to the honorable court. In the beginning of my arguments on the first day I submitted, I only can quote the dialogues of Portia from Merchant of Venice. That's all, my lord. I know where if I am also in the portion of
pound of flesh ಬೇಡ ಅಂತ ಇದ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ, ನಮ್ಮ ಸ್ನೇಹಿತರ ಜಾಗದಲ್ಲಿ ನಾನು ಇದ್ರು ನಾನು ಅವರಷ್ಟೇ ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದೆ.
ಗಲಾಟೆ ಏನಿಲ್ಲ ಸರ್,
ಅಲ್ಲ, it's better. See, you have encroached, you have settled.
ಖಂಡಿತ ನಾನು ಹೇಳ್ತೀನಿ, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ
settle ಮಾಡಿ whatever amount you want, you negotiate.
Please.
But ultimately, fact remains that you have encroached.
Yes, my lord. I can't say. My lord,
he will not ask pound of flesh and Merchant of Venice. Don't worry. Yes.
My lord, is it if it is before the Chikmagalur mediation center?
ಅಲ್ಲ ಅದು already.
ಯಾಕಂದ್ರೆ ಅವರು ವಯಸ್ಸಾಗಿದೆ, ಬರಕ್ಕಾಗುತ್ತೆ.
Where are the parties?
ಚಿಕ್ಕಮಗಳೂರು.
ಅಲ್ಲೇ ಮಾಡಿ. ಅಲ್ಲ ಇಲ್ಲಿ ಕರ್ಸೋದು ಯಾಕೆ? ಅಲ್ಲೇ ಮಾಡೋಂಗ್ ಮಾಡಿ. ಇಲ್ಲ, better you both of you are there, I guess. I don't know. In the Bangalore mediation center.
My lord, 8th, 9th, 10th ನನ್ನ ಮ್ಯಾರೇಜ್ ಇದೆ ಮನೆಯಲ್ಲಿ.
ನಿಮ್ಮ ಮ್ಯಾರೇಜ್
ಅಲ್ಲ, ನನ್ನ ಮ್ಯಾರೇಜ್, ನನ್ನ ಮಗಳ ಮ್ಯಾರೇಜ್, ತಮ್ಮನ ಮಗಳ ಮ್ಯಾರೇಜ್. Therefore, my lord,
ಬ್ರೇಕಿಂಗ್ ನ್ಯೂಸ್ ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ.
ಅದಕ್ಕೋಸ್ಕರ ಅದಾದ್ಮೇಲೆ ಕೊಡಿ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ನಾನೇ ಪರ್ಸನಲ್ ಆಗಿ ಹೋಗ್ಬೇಕು.
ಆಯ್ತು, ಡಾಕ್ಟರ್ ಮ್ಯಾರೇಜ್ ಪರ್ಸನಲ್ ಆಗಿ ನೀವೇ ಇರ್ಬೇಕು. ಆಯ್ತು,
ಆಗ್ಬೋದಾ ಸರ್?
ವಿಲ್ 15ಕ್ಕೆ ಹೋಗಿ ವಿಲ್ ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 23rd. Yes, ಆ ಡೇಟ್ಸ್ ವೇರಿ ಮಾಡಿ ಜೀವ.
ಪ್ಲೀಸ್.
Yes.
55.
In this case, respondent number 1 had remained ex parte.
Respondent number 1 na?
Yes, remained ex parte. He is the person who claims to be the power of attorney holder, Miller. And I am seeking suspension of notice to him, Miller.
What's the
issue?
Issue?
What has happened is this, Miller. Suit is filed by the petitioners for declaration and injunction.
Dispose ಮಾಡಬಹುದಾ ಅಂತ ಇಷ್ಟೇ. ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್.
ಹೇಗಾದ್ರೂ ಸರಿ, ತಮ್ಮ ಟೈಮ್ ಇದ್ರೆ ಸರಿ, ಇಲ್ದಿದ್ರೆ
ಡಾಕ್ಟರ್ ಅವರು ಏನು?
Malad, the after vacation, this is the Malad, only the court piece, we have filed 7 Rule 11B for.
According to me, Millard, what has happened is
immediately
converted land. Intermarket ಇದೆ.
Will post it on 9th October.
Oh, please.
List the matter on 9th October. Interim order subsisting will continue to the next year. Yes.
56 withdrawal.
In terms of, yes.
57.
Plaintiff in this case, my lord.
Yes. Yes. Restrained from changing the nature of the property.
Yes,
Alle hogi. 39(1) and 2 rejected, right?
Yes, my lord. First stay order grant ಆಗಿತ್ತು, my lord. Then after they, first the stay order was granted. After they filing the objection, it was dismissed. ಅದಕ್ಕೆ. Now they are in the, they are trying to change the nature of the property.
They
my
filed
lord.
MA, they filed MA, the court did not give an interim order in the MA, my lord. Therefore,
All right,
they
ಈಗ MA pending ಇದೆಯಾ?
pending it.
I will direct the first appellate court to decide the issue. Will continue this order till the decision of the issue.
Yes.
That's all.
Some time limit in that MA.
That, the petitioner is before this court seeking the following prayer. The petitioner is the plaintiff, files a suit in OS 124 of 2025 injunction, right?
Yes, my lord.
Suit for injunction. The concerned court declines to grant an order of injunction after hearing the parties, which leads the petitioner, the plaintiff, before the first appellate court. And before the first appellate court, the petitioner seeks an interim order of interim injunction as was sought for before the trial court, which was not granted. The first appellate court also does not grant any order of temporary injunction as was sought for, but only issues notice. It is at that juncture the petitioner plaintiff knocks at the doors of this court. The proceedings are pending before the first appellate court. This court, in order to protect the interests of the petitioner, had passed the following order on 1/9/2025. The learned counsel appearing for the parties would submit that if a direction is issued to the first appellate court to dispose the appeal within a time frame and the subject order be continued till the said date would suffice. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the concerned court to dispose the miscellaneous appeal filed against an interlocutory order of the concerned court within an outer limit of 8 weeks from the date of receipt of the copy of the order. In the light of the order dated 1/9/2025 quoted supra being in subsistence even today, I deem it appropriate 19/18/8 ಎರಡು quote ಮಾಡಿ 18/8 and 19 so and so quote ಮಾಡಿ. I deem it appropriate to dispose the petition with a I deem it ಏನು ಹೇಳಿದೆ ಕೊನೆಗೆ? In the light of the subsistence of the order dated 1/9/2025 or 18/8, the order shall continue till the disposal of the miscellaneous appeal, which is directed to be concluded within 8 weeks from the date of receipt of the copy of the order, ordered according. ಅಲ್ಲಿವರೆಗೂ continue ಆಗುತ್ತೆ.
Let they not interfere with the possession also.
Stay continue ಮಾಡಿದ್ದೀನಿ. What is this? Yes.
58.
Lords, I appear for the respondent 1 to 4, but seek 2 weeks time to file
Learned
objections.
counsel for the respondent seeks 2 weeks time to file statement of objections. Objections, if any, be filed by the in the next 4 weeks. Interim order subsisting will continue.
59.
Yes.
So date may be fixed.
You move ಮಾಡಿ sir.
2 to 5. I will file the objections, my lord. Kindly have it done next week.
Last week Renuka madam appear ಆಗಿದೆ.
ಏನು ಹೈಡ್ ಅಂಡ್ ಸೀಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಒಂದ್ಸರಿ ರೇಣುಕಾ ಮೇಡಮ್ ಬರ್ತಾರೆ, ಒಂದ್ಸರಿ ಸುರನಾ ಸರ್ ಬರ್ತಾರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್?
ವಕಾಲತ್ ನಾವೇ ಸುಮ್ಮನೆ. PDC ವಕಾಲತ್ ನಾವೇ ಹಾಕಿ.
ವಕಾಲತ್ ನೀವೇ ಹಾಕಿದ್ರು. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್? ಯೋ ದಿಸ್ ಇಸ್ ದಟ್ ಯಾರು ತಗೊಳ್ಳಿಲ್ಲ ತಾನೇ ಇದು? GM. ಸರ್ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಲ್ವಾ?
Kindly have it done next week, my lord. I will file the objections.
Yes. Heard the learned senior counsel Vikram Huligold appearing for the petitioner. The learned senior counsel submits that this court had by a detailed order granted an interim order of stay. The order dated 5/8/2025 reads as follows. The learned senior counsel would project that the petitioner participated in the tender and took the subject property on lease when no person was coming forward.
No tender then, in 2012.
No tender. Took the property on lease when no person had come forward to even take the property, as the tender had failed without any response. The learned counsel for the respondent submits that objections are required to be filed in the case at hand. The objections be filed by the next date list on 31st October for further hearing, since it's special order matter. Further hearing, interim order subsisting will continue to the next date.
60.
Suit for declaration and injunction. My lord, the court was pleased to grant an order of status quo, directing the parties to maintain status quo in respect of the property. When the matter was heard and reserved for judgment.
Where?
The order before the trial court.
Alli,
Trial
yes,
court. When the matter was heard and reserved for orders on the application for injunction, the defendant, my lord, put up a barbed wire fence. So that, my lord, I am obstructed from going to my property which is located on the hind side.
I have recorded that.
Yes, my lord, now I am
Yes,
blocked.
sir. You said fence ಬಗ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ last time
They
ಅಂತ.
are not obstructing the way of this plaintiffs, my lord.
Fence ಹೆಂಗ್ ಹತ್ತಾರೆ sir ಅವರು?
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ನಾವು
Fence
That is the finding of the trial court. That it has been done.
You have put up a fence and you are sitting on the fence. How will he come?
Barbed fence surrounding the my property only, written statement scheduled property. We never encroached an inch of property of these plaintiffs. They made certain allegations.
Let the trial court appoint a commissioner.
Trial court is of the opinion, my lord.
Let the trial court appoint a commissioner.
ಸರ್ವೆ ಆಗದೆ, ಮೂರು ಸಲ ಸರ್ವೆ ಆಗದೆ.
ಯಾಕೆ?
ಮೂರು ಸಲ ಸರ್ವೆ ಆಗದೆ.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಸೂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಡಿ.
Putting up of barbed wire fence is.
No, don't worry.
ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಹಾಕೊಂಡು ಡಿಕ್ಲೇರ್ ಇನ್ನ ಅವ್ರ ಪ್ರಾಪರ್ಟಿನೇ ಡಿಕ್ಲೇರ್ ಆಗಿಲ್ಲ. ನಮ್ದು ರಿಮೂವ್ ಮಾಡ್ಬೇಕು.
ಒಂದೇ ನಿಮಿಷ.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳೋದು
ತಂತಿ ಪ್ರಾಬ್ಲಮ್ ಒಂದ್ ನಿಮಿಷ ಸಾಲ್ವ್ ಮಾಡಿ.
ಫಸ್ಟ್ ಆಫ್ ಆಲ್ MA ಆಗ್ಬೇಕಾಗಿತ್ತು ಅವ್ರು. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ IA ನಂಬರ್ 4.
After hearing both the parties.
After hearing the both the parties.
After ಯಾವುದು?
ಅದಾಗದಿರ
ಒಂದ್ ನಿಮಿಷ ಸರ್.
ಅಲ್ಲ ಯಾವುದು IA ನಂಬರ್ 3 ಮೇಲೆ ಸ್ಟೇಟಸ್ ಆರ್ಡರ್ ಇದೆ.
ಸರ್ 4 ಸರ್.
IA ನಂಬರ್ 3 2 and 3.
ಚಾಲೆಂಜ್
Anyway,
ಮಾಡಿ
we'll send it before. ನೀವು ಸೂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡೋದು ನಿಲ್ಸಿ ಇಲ್ಲಿ. You are under 227 ಅಷ್ಟೇ. Yes.
2 and 3 ಅಲ್ಲಿ ಸ್ಟೇಟಸ್ ಆರ್ಡರ್ ಇದೆ.
The petitioner is before this court seeking the following prayer. The allegation of the petitioner was that in the garb of grant of new defendant,
Now plaintiff.
in the garb of an injunction of the suit schedule property in favor granted in favor of the defendant.
ಅಲ್ಲ ಇಬ್ರಿಗೂ ಸ್ಟೇಟಸ್ ಮೇಂಟೈನ್ ಮಾಡಿ.
ಒಂದು ನಿಮಿಷ.
ನಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್.
ಇಬ್ರಿಗೂನಾ? The learned counsel for the petitioner submits that on the garb of or in the taking advantage of the status quo order that is granted by the concerned court.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ quo order was passed before the matter was after the matter was reserved for orders. They have put up the barbed wire fence. Order ಅಲ್ಲಿ
Matter reserve ಆಗಿತ್ತಾ?
matter reserve ಆಗಿತ್ತು.
The petitioner is the plaintiff institutes OS 475/2024 seeking injunction against the respondent. The matter is the concerned court had granted an order of status quo. The status quo order was in subsistence throughout. The matter was heard and reserved for its orders.
Status quo order ಕೊಡೋದಕ್ಕಿಂತ ಮೊದಲು when the matter was reserved for orders, they put up the barbed wire fence.
Yes. I will sit on the fence. Yes. ಏನು ಹೇಳಿದೆ ಜೈ? ಅಲ್ಲ ಸರ್, the matter was heard and reserved for orders. The status quo ಯಾವಾಗ ಕೊಟ್ರು ಮತ್ತೆ?
18 to 25
ರಿಸರ್ವ್ ಆಗಿದೆ ಯಾವತ್ತು?
ರಿಸರ್ವ್ 31st ಗೆ.
The matter was heard and reserved for orders on 31/1/2025. It transpires that later an order of status quo was passed on the score that between the dates of the matter being reserved and the order of status quo being granted, the respondent had put up a barbed wire. It is but ಇಲ್ಲಿ ಯಾಕೆ ಬಂದ್ರಿ?
We filed an application seeking.
An application was then filed for removal of the barbed wire, which comes to be rejected. Rejection of which has driven the petitioner to this court in the subject petition. The learned counsel for the respondent defendant submits that the fencing is done only to the written statement schedule property and not an inch of the property of the petitioner or the plain schedule property is touched. In the light of the said what the learned counsel for the petitioner would dispute the position, as he is now in a position that he cannot enter his own property due to the barbed wire that is placed. In that light, it would be open to the concerned court to appoint a court commissioner to inspect the property and draw up a report with regard to the fence, the encroachment by putting up of the fence by either of the parties in either of the suit schedule or the written statement schedule property, for which purpose the present petition need not be detained before this court. For the aforesaid reasons, the following order. The writ petition stands disposed, notwithstanding the rejection of the application, notwithstanding the impugned order, the concerned court shall now, and shall now appoint a commissioner seeking to draw up a report with regard to the allegations and contra allegations of both the plaintiff and the defendant, and pass necessary orders after the receipt of the report from the hands of the concerned commissioner. Yes, ordered according. The petitioner is at ಏನ್ ಟೈಮ್
ಅಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್
injunction ಮಾಡ್ತಾರೆ.
ಯಾಕಂದ್ರೆ
In the light of the fact that judgment was all, the matter was already reserved for its judgment, after the receipt of the report of the commissioner, the concerned court shall endeavor to conclude the proceedings within 2 months thereafter.
One request, please. Take the documents which are relied by the both the parties should be considered.
In accordance with law ಅಂದ್ರೆ ಅದೇನೆ.
Sticking to my property in.
ಅದೆಲ್ಲ ಆಮೇಲೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
Suit for partition and declaration. This is the case where the children have filed a partition against the father. Please, my lords.
As I may seek for a short passover, my lord.
Short passover.
Seniors held up in he's arguing another matter and.
Short passover. Yes.
Grateful.
Passover. Yes.
62.
But in this case, with kind permission, one submission. On 1/9/2025, this court has heard the matter for some time. Thereafter, this court has directed this office to connect the another matter, writ petition number 25,283 of 2024.
It's a GM Waqf matter. This is a
GM Waqf,
partition.
there is an interim order. This
ಅದಕ್ಕೆ ಇದಕ್ಕೆ
petitioner is
ಸಂಬಂಧನೇ
also
ಇಲ್ಲ.
party to the proceedings, my lord. The petitioner before this court, he is also party in this proceedings, my lord. Kindly see that. I'll give this cost.
Tag along with ಅಂತ ಹೇಳಿದಿನಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ.
we
But
did not know that.
kindly see.
ಆಗಿತ್ತಾನೆ.
Also, my lord, when the interim order was operating, they entered the agreement of sale.
Wait.
Sorry.
Yes,
Sorry.
sir.
Lord, on that day he made the submission. We were not aware of that, Lord, but that is a GM Waqf matter where somebody is claiming it to be a Waqf property. Now this is the partition suit only. There is a final decree. Now the final decree has been stayed by Lord the appellate court, Lord, against which we are here, Lord. So ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. If he shows any connection to this case and that case, Lord, then
Let him show the connection later.
Subject matter involved here and in the one and the same, lord, the same survey number.
property ಇದ್ರೆ
ಈಗ ಟ್ಯಾಗ್ ಮಾಡಿದಿನಲ್ಲ ಆಲ್ರೆಡಿ.
ಹೌದು ಸ್ವಾಮಿ.
that's correct, Lord. That's wrongly done actually.
No, no.
ನಮಗೆ ಅದು ಗೊತ್ತಿರಲಿಲ್ಲ.
ಬಂದಿದ್ಯಾ ಇದು?
ಇಲ್ಲ it was not-
ಬಂದಿಲ್ವಲ್ಲ ಇನ್ನು?
ಹಾ ಬಂದಿಲ್ಲ.
The
Listed
petitioner
on 23/9.
It was listed yesterday before another court.
The petitioner before this court, he is also one of the respondent number 16 in this writ petition. The subject matter
I think,
involved here and also the one at the
No,
same.
what's the matter?
Lord, this is a partition suit, my lord. There are four sharers. My lord, the suit is decreed. Thereafter, my lord, the father of the respondent filed an appeal. The appeal is dismissed for default. Till today, it is not restored, my lord. After 10 years also, it is not restored. 2015, it is. Thereafter, my lord, we have filed final decree proceedings. Final decree proceedings, only court commissioner is appointed. The 4 shares, my lord, are marked out. And my lord, we have allotted our 3 shares and he has got, my lord, 1 share, my lord. Now he has sold away that share also. Thereafter, he files an appeal before the, against the final decree. Now the appellate court, my lord, stays the final decree proceedings after all the proceedings are, my lord, have culminated. Now our
The
shares.
final decree proceedings are over, is it?
Final decree proceedings are over. Against that, my lord, he has filed an appeal. So first.
No, against the FDP of the year 2007.
Yes.
He files an appeal in 2024. Is
No,
that
no.
correct?
FDP, yes, my lord.
Who is the appellant?
I am the first petitioner, the respondent before this court is the appellant.
ಯಾಕೆ 17 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲ, ಈಗ ಮೊನ್ನೆ ಆಗಿರೋದು.
ಅಲ್ಲ
FDP ಕ್ಲೋಸ್ ಆಗಿದ್ಯಾ ಅವಾಗ?
26 to 2024 ಅಲ್ಲಿ. 26 to 2024 again that I filed a writ petition. Sorry.
ಅಷ್ಟೇ ಕೇಳಿ.
Now, my lord, his application.
Second appeal is res judicata. ಮೊದಲು ಒಂದು ಹಾಕಿ dismiss for default.
ಯಾವ್ದು ಮೊದಲು ಯಾವ್ದು ಹಾಕಿದ್ರು ಸರ್? ಸೀನಿಯರ್ ಹೇಳಿ.
Now, Lord, first thing is that, Lord, having not appealed against, Lord, or having allowed the appeal, Lord, against the preliminary decree to be dismissed, Lord, as appeal, Lord, under section 97 of the CPC, Lord, is not maintainable, Lord, against the final decree proceedings. Secondly, Lord, his application
appeal
was
is
stayed.
entertained, is it?
Yes, it is entertained. Now, in his application, if your lordship sees, his application at page 60 and at page.
Now, who is he?
He is one of the sharers.
One of the shares.
Now he has sold away the property. Entire property has sold. He has absolutely no subsisting right today. Lord, before the FDP court, Lord, 3 times the court commissioner has issued him notices.
He does not appear. He does not participate. Now he is challenging it. And please see the application for stay, my lord. What he says is at page 72, if your lordship comes. Lord, he says that my grandfather was, my lord, performing the duties of a mutawalli. Thereafter, my lord, my father was doing it. He applied for occupancy rights. Those occupancy rights were granted in the name
ಈಗ
of
what is that you have challenged?
I have challenged the stay granted, my lord, by the FDP court. My lord. And please
By
see the
by
order
the first appellate court
First appellate
of the FDP
of
proceedings.
the FDP proceedings.
Yes, sir.
My lord, kindly see that my statement of objection I filed, my lord, annexure R23, my lord. That is my statement of
I
objection.
will hear this after vacation.
Yes, my lord, because
What's
and
what's the
also, my
next
lord,
date?
Next date.
2410 is the, in another connected matter, 2410 is the given the date, my lord.
ಅದ್ರಲ್ಲಿ
Atrali sum.
ನಾನು ವಕ್ಫ್ ಬಿಡಿ ಸರ್ ಇದೆ ಯಾವತ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್
He is entitled to
we
object.
will fix it on 9th.
9th.
List the matter on 9th October.
With submission, my lord. Only one submission, my lord.
I will not take that.
Agbodu.
List
My
on
lord, one
9th.
submission, only one submission, my lord. The petition filed by this petitioner is not maintainable.
That
For
we'll
the
hear
reason
it
is
later.
this, my lord. During the pendency of that regular appeal, the father of this petitioner has compromised this matter and he has taken his share
There's
and
no
he filed the
compromise, my lord.
compromise petition in the this regular appeal.
There's no compromise.
Right. Much of it. Because the writ petition itself is not maintainable, he has no locus standi.
9th ವರೆಗೂ ಮೇಂಟೈನಬಲ್ ಆಮೇಲೆ ನೋಡಿ. Yes.
Much of it.
63.
Hello to the respondent, my lord. I request a week's time to file objections.
Okay, for the petitioner, my lord.
Yes, Anusha.
This is the matter in which application for amendment was filed. The trial court has rejected, the commercial court has rejected the application on the ground that they are seeking to withdraw certain admissions. That was the main contention before your lordship, stating that we are not trying to withdraw any contentions. Your lordships had asked them to file statement of objection.
Just a week's time, my lord. I'll file.
It may be called on the reopening day, my lord.
8th.
Much
Heard the learned counsel Srimati Anusha and Ajesh Kumar. Lest the matter, learned counsel Ajesh Kumar seeks 2 weeks time to file statement of objections. List the matter on 8th October.
Much. 64.
Two more matters are connected to the current batch.
Huh?
Two more matters are
ಕೊಡಿ
connected.
ನಂಬರ್ ಕೊಡಿ. ಏನ್ ಸ್ಟೇ ಆಗಿದೆ ಈಗ?
But we had sought for clubbing here.
ಕ್ಲಬ್ಬಿಂಗ್
Clubbing of 3 suits which were filed on the same court's file. And plaintiffs are the same, different defendants, but the same parcel of land.
There are three mortgage deeds separate. Evidence has already started.
are the 3 mortgage deeds between the same parties?
Separate.
The parties are not the same.
Different properties. It is same survey number, different properties.
Same survey number, my lords. In HD Kote, my lords, these were land tillers, who were not able to apply for their rights. Now what the landowners have done, my lords, is something like this, where they have done a mortgage with the same people, tillers. And my lords, they have said that we have let you in on possession. Now, my lords, the same parcel of land, the landowner files 3 sets of suits on the base of the said.
ಕರೆಕ್ಟ್ ಆಗಿ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೇಳ್ಬೇಕು.
ಒಟ್ಟಿಗೆ ಕೇಳಿದ್ರೆ ಮುಗ್ದೋಗುತ್ತೆ. State government is also involved.
ವರ್ಷ ಇಯರ್ ಯಾವ್ದು ಸೂಟ್ಸ್?
All of them are the year 2012. 2012.
ಮೂರು.
Not what I'm telling is not that. Not what instead of not there are 3 documents separate. Evidence has been started. But this apprehension is one will have a bearing on the another. But ಒಂದೇ ದಿವಸದಲ್ಲಿ at a simultaneous 3 ಒಟ್ಟಿಗೆ ಮಾಡಿ.
ಈಗ ಕ್ಲಬ್ಬಿಂಗ್ ಆಗಿದೆಯಾ ಅಥವಾ ಆಗ್ಬೇಕಾ?
ಕ್ಲಬ್ಬಿಂಗ್ ಆಗ್ಬೇಕು.
But clubbing ಆದ್ರೆ ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಬೇರೆ
ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
ಅದರಿಂದ ನಾವು what I'm trying is simultaneously ಒಟ್ಟಿಗೆ ಮಾಡಿ.
It will save time and conflicting orders.
Not that. That is why.
ಕೊಡಿ petitions ಕೊಡಿ.
That is the reason. That's why.
Tag this petition along with so and so. The learned counsel appearing for the petitioner T. Sunil Rao submits that there is an intermodal, I know, I'm just elaborating it. They tag this petition on so and so. The learned counsel for the petitioner Shri Sunil Rao submits that there are 3 suits all of the year 2012, all between the same parties, all concerning mortgage deeds. Though the property involved in the mortgage deeds is different in same property, though the property the property involved in the mortgage deeds are from the same survey number. The learned counsel for the respondent would seek to distinguished the said, dispute the said fact by contending that the survey numbers may be the same, but it is of different properties, therefore the suit should not be clubbed.
Different mortgages.
And it is arising out of 3 different mortgages.
And I have no objection, my lord, to dispose of simultaneously together, my lord.
Together ಆದ್ರೇನು ಸುನಿಲ್
ಅಂದ್ರೆ
ತೊಂದ್ರೆ?
ಬೇರೆ ಬೇರೆ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಒಟ್ಟಿಗೆ
Club
ಮಾಡಿದ್ದಾರೆ.
ಆದ್ರೆ ಒಂದೇ ಎವಿಡೆನ್ಸ್ ಆಗುತ್ತೆ. We'll be
ಇಲ್ಲ,
giving you
together
a
ಮತ್ತೆ conflict.
PW1,
yes.
PW2,
ಅದಕ್ಕೋಸ್ಕರ.
So
I have no objection.
in the light of the said, the learned counsel for the respondent submits that he has no objection for all the 3 suits to be taken up together and disposed, but not clubbing.
Yes.
In the light of the said submission, it becomes a case where it has to be clubbed. Therefore, now we'll club with other cases.
Yes, please.
Therefore, the other 2 petitions be tagged. The interim order subsisting would continue till the next date of hearing. Yes.
This is that craft beer, bottle beer matter, my lords.
Oh,
For respondent number 1, my lords.
ಯಾವ ಬಿಯರ್ ಮಾರ್ತಾ ಇದ್ದೀರಾ? 18 commune.
Yes, bottle beer we are selling, my lords. We have the
They're selling
accounts also.
bottle beer.
Only we are selling right now bottle beer. We given undertaking that we will not sell craft beer and tap beer. We are selling only bottle beer. I have the accounts also matters before the trial court tomorrow. I'll file the accounts before the trial court tomorrow.
We'll
I have it
close
here.
this.
I'll file objections, my lords.
Which beer you want?
No, my lords, my only contention is, my lords, they have filed this petition for an application seeking clarification for the interim order that I had.
What clarification?
Please, my lords.
Oh,
So the trial court had.
Trial court said don't sell anything.
Don't sell any beer not manufactured by me, my lords.
Not manufactured by that different number 2 who are in connivance with each other. He's the plaintiff. Different number 2 is the person with whom they have an
What
agreement.
beer do you manufacture?
My lords, I have actually procured the equipment for the manufacture of the beer, my lords. And
What is that
respondent-
brand?
My lords, it's a craft beer, my lords.
It's a craft. They're not selling craft beer.
Please, my lords. So what has happened is, because they have not sold the craft beer, and as it is evidenced in the tripartite agreement which is signed by all parties, they're not permitted to sell any beer that is not manufactured by me, and they've given an undertaking not to sell bottled beer, my lord. That's why I require time to
Yes,
file
and-
objections.
My lords, kindly see the clause. My lords have seen the clause and then given me the order.
It's a detailed order.
Yes, my lords. My
Trio
lords have seen the
agrees
clause.
that during the term of this agreement, it shall not sell any other craft beer or tap beer other than craft beers produced by ECB.
Yes.
He is not selling craft
My
at
lords,
all.
when the contract is read as a whole, my lords, there is an
No,
implication.
this is part of the contract I have extracted.
Please, my lords, but when there are several other clauses in the contract that also imply
Well,
that.
you let him file his
that we-
objections.
Please, my lords, 2 weeks time may be given.
Till then, you have the October Fest. Yes. This court on 3/9/2025 had passed the following order. The learned counsel appearing for the respondent would submit that the petitioner should not be permitted to sell even bottled beer, as the contract is a whole, should be viewed as is one whole document and not fragmented. This court, while granting an interim order, had extracted clause 11 of the very agreement that the respondent now seeks to place reliance upon. In that light, the interim order would stand extended till the next date. Objections, if any, shall be filed by the respondent by the next date. List the matter on 23rd October.
Obliged.
Sorry. Lords, can it be after 25th, my lords? 23rd, I think I have some difficulty somewhere. 25th.
No objection.
27th.
Obliged.
In regard to the.
Appear for the respondents, undertake to file wakalat minutes. Copies were served on 22nd on the trial court advocate. I have instructions.
66, sir.
Please, madam.
This is in regard to the,
Instructions
my lords, I'm pressing for stay, my lords, for the.
Pressing for stay.
For the only reason, my lords, that the matter is now set down day after tomorrow. It is being
what?
taken up for defendant cross-examination, my lords.
What's the issue?
My lords, the issue is this, my lords, that issues were framed.
Issues were framed. All right.
Yes, my lords. My lords may kindly peruse the issues, my lords.
What's
that
the issue about issue being
Sir,
framed?
the suit is one for bare injunction, my lords. In a suit for bare injunction, it's basically a suit by a tenant against a landlord.
All right.
My lords, in that suit, my lords, there is an admission in regard to the title of the defendant.
All right.
My lords, the trial court, my lords, frames around 14 issues. In those 14 issues, my lords, 4 issues are in regard to the title of the defendant.
All right.
My lords, those issues I sought to delete, my lords. I filed an application.
Because it's an injunction suit and title cannot be gone into.
Yes, my lords. What happens is this, my lords, if at all, if the title is being looked into.
I file your objections. The petitioner is before this, petitioner is the defendant. Defendant, huh?
Petitioner-
Plaintiff. Petitioner is the plaintiff. He is before the court calling in question an order which permits recasting of issues or framing of additional issues. The issue is with regard to the landlord and the tenant. The suit is instituted for injunction. The learned counsel for the petitioner submits in an injunction suit out of the 14 issues that are already framed. 4 issues are go into the title of the plaintiff. The learned counsel submits that in an injunction suit, the court cannot frame an issue which goes to the title, as it is a dispute between the landlord and the tenant. In that light, further proceedings before the concerned court shall remain stayed till the filing of the statement of objections by the respondent or the 30th of October, whichever is earlier, list on 30th. Interim order,
My lords may have it minutes on the reopen India rather than on 9th.
ಹಾಕ್ತೀರಾ ಅಷ್ಟರಲ್ಲಿ?
I'll file it.
ಆಯ್ತು, list on 14th October.
Order of this court minutes was on 15th. They could have served me an earlier copy minutes. I would have appeared with the instructions. On 22nd, they serve a copy minutes. I'm
I
here.
tried my lords, our office.
ಇವ್ರು ಸಿಕ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
ಅಲ್ಲಲ್ಲ, ಇವರಲ್ಲ. The on record counsel my lords ಅವರಲ್ಲಿ.
ಆಯ್ತು,
On 9th minutes at least.
9th ಇಲ್ಲ, 14th.
Please, because they are in possession of the property and the agreement has come to an end by termination.
That is.
Solid. You are the tenant.
Alla, father and son, my lords. It's father and son.
Father and son. 30th ಬರ್ಲಿ ಬಿಡು.
Alla,
Yes.
my lords, agreement has come to an end.
Father and son dispute ಗೆ ಟೈಮ್ ಇಲ್ಲ ಇಲ್ಲಿ.
Alla, 14th my lords.
List on who is the father, who is the son.
I'm the father and the respondent.
ಅವರು ಅದನ್ನೇ ಹೇಳಿದ್ದು. Wait, ಇಬ್ಬಿಬ್ರು ಹೇಳ್ಬಿಟ್ರೆ ಯಾರು father ಯಾರು son ಗೊತ್ತಾಗಲ್ಲ.
Defendant is the father, that is the respondent.
You are the father, is it?
Please.
Have some mercy on the son.
Alla, we have my lords, but he is not paying anything to us. Therefore, my
You are
lords.
the son.
My lords, I have all the.
You are the son.
Yes, my
Have
lords,
some
I'm
mercy
paying
on the
all.
father. List the matter on 31st.
My
Yes.
lords, 14th minutes married.
ಬೇಡ ಬೇಡ, ಸಾಕು. ಬೇರೆಯವ್ರದ್ದು ಕೇಳೋಣ.
Our possession leader, therefore that is my difficult.
ಮಗ is in possession, so very.
I can't be in possession of the property.
No
That is
problem.
the issue.
31st, yes.
60, admission 67.
Matter may be passed over, my lord.
Passed over?
Sir, petitioner has submitted that he is going to file the affidavit, my lord.
Oh, tenant ಆ?
I'm landlord.
ಅದು ಗೊತ್ತಾಯ್ತು, you are landlord.
Yes, ma'am.
Pass over. Yes.
68.
Casablanca.
Yes.
Extortion proceedings.
My lord, what's this? Instead of admission, late payment, fixed payment, disposed of fine, call for the
yes.
records in. He has
We
not
will not
produced-
permit ಅದೇ
No,
ತಾನೇ
extortion.
ಕೇಳಿದ್ದು ಅವತ್ತು.
Yes, madam.
This is the one, right, where
Third.
earlier third round you said, yes, sir.
Yes, I am ready, man.
Yes, sir.
My lord is pleased to see, my
ಅಲ್ಲ
lord.
ಅವ್ರು ಹೇಳಿ.
My lord, we are filing some papers which they have not filed, which is necessary, which is part of the
Oh,
trial court.
tell me what
records.
it is.
Yes, my lord. My lord is pleased to see the plaint, my lord, ink page 43. My lord, what happens is this, the plaintiff is one Yashoda Subramanian.
ಅಲ್ಲ earlier order ತೋರಿಸ್ಬಿಡಿ ಯಾವ್ದು?
Yes, my lord.
You said some order is passed by coordinate bench that is affirmed by Supreme Court.
Yes, yes.
ಆಮೇಲೆ this has come up. ಅವ್ರು ಹೇಳಿದ್ದೆ.
ಅವ್ರು ಹೇಳ್ತಾರೆ, ಆಯ್ತು. ಅದು ಪಕ್ಕದ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು. We
ಪಕ್ಕದ
wanted a
court ಆ?
modification from scheduled property to 104. That review petition was rejected on that limited ground of that mistake.
ಅಲ್ಲ earlier the council said plaint had been rejected.
Rejected.
By unknown.
No.
One of, there was another
Not
plaint.
ನಿಮ್ದಲ್ಲ,
Not-
ಇನ್ನೊಬ್ರು.
not- A plaint, my lord, in OS 437 of 2020 came to be rejected by this honorable court. As against that order, the plaintiff therein filed an SLP before the honorable Supreme Court, which came to be rejected also.
All right.
As against the rejection by this honorable court, the plaintiff herein, my lord, who is represented by learned senior counsel, also filed an SLP, even though they were defendants in that suit.
They,
Yes.
yes. What happened to that application?
That is lying pending, my lord, in the honorable Supreme Court.
So ಒಬ್ಬರ ತೀರ್ಮಾನ ಆಗಿದೆ.
Ananti has nothing to do with.
ಅನಂತಿ?
That person who is supposed to have filed. ಅದು ಬೇರೆ ಯಾರ್ದೋ ಕೇಸ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ ತಗೊಂಡ್ಬಂದು ಅನಂತಿ ಅಂತ ಪದೇ ಹೇಳ್ತಾರೆ. Went to Supreme Court.
ಇರ್ಲಿ, ಅನಂತಿ ಯಾರು ಸ್ವಲ್ಪ ವಿನಂತಿ
ನನಗೆ
ಮಾಡಿದ್ರೆ
ಗೊತ್ತಿಲ್ಲ.
ಹೇಳ್ಬೋದು.
ಬೇರೆ ಯಾರೋ ಇದ್ದಾರೆ. They claim survey number 104 which has been acquired. Justice
Now,
Rama Joy's
the thing
division
is
bench
with,
judgment ಇದೆ.
Khatas are given.
Division bench
So
judgment.
survey
ಇದೆ.
numbers no longer are.
No, it's extortion ಅಂದ್ಬಿಟ್ಟು ಅನ್ವಾ.
ಅದು extortion ಹೇಳ್ಕೊಂಡು their property has been acquired years ago. ಇವಾಗ ಅವ್ರದ್ದು ಎಲ್ಲೂ ಇಲ್ಲ ಜಾಗ, ನಮ್ದು ಅಂತ ಹೇಳ್ಕೊಂಡು ಇತ್ಲ ಕಡೆ ಬಂದವ್ರು.
ಆಯ್ತು,
ಅನಂತಿ ಅಂತ ಒಂದ್ ಏನೋ ಒಂದು ಸೆಟಪ್
Will
ಮಾಡ್ಕೊಂಡು,
hear,
ಅನಂತಿ ಅಂತ ಯಾವ್ದೋ ಒಂದು ಸೂಟ್ ಸೆಟಪ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ.
I don't want to say anything.
I also don't. That's why I said, Lordship may call for the trial court records.
Will do
I've
it, yes.
prepared a whole compilation.
ಕೊಡಿ,
In
compilation
document.
ಕೊಡಿ.
ಕೊಡಿ ಎಲ್ಲ ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ಇದ್ರೆ ಕೊಡಿ.
ಕನ್ವೀನಿಯನ್ಸ್ ಬೇಡ, ಫುಲ್
ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ಇದ್ರೆ
They've already filed it.
Yes.
ಇದು ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ಆಗ್ಬಿಡ್ತದೆ. Give me one set.
Sir, we have filed
Right,
it.
we'll hear it on 30th.
What?
30th we'll hear it.
That's why I said,
Compilation ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, ma'am.
Yes, list on 30th at
I may also
3:30
be
PM.
permitted to put together all the
ಎಲ್ಲ
papers.
ಮಾಡಿ, yes, sir.
ಎಲ್ಲ ಮಾಡಿ ಕೊಡ್ತೀನಿ.
30th, 3:30 PM, yes.
My lord, every time a
30.
new defendant,
October.
a new defendant comes in as a plaintiff.
That's precisely the reason why I won't hear it.
Yes.
Yes.
A person whose property is, his lordship Justice Ramajoy's judgment is there. In their
ಆ
sale,
ಕಾಲದ
ಆ ಕಾಲದ ಅಕ್ವೈರ್ ಆಗಿದೆ, 78 preliminary notification. Iವ್ರ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ the vendors have just completely bypassed the acquisition and said, no, we got it intestate ಇದ್ದದ್ದು ಹೇಳ್ಕೊಂಡು ಇವ್ರಿಗೆ ಮಾರ್ಬಿಡ್ತಾರೆ. Their property doesn't exist.
My lord, they have not acquired my property. The
ಆಯ್ತು,
person-
we'll see. 30th, yes.
69.
Here for the petitioner. 4 to R7. In this matter, your lordships will recall it came before your lordships a few weeks back. Lord, this is like in a LAC court order asking R1 to R3 to deposit the amount they had illegally obtained after colluding with the KADB. At that time, Lord, the money that was given to R1 to R3 was about 30 crores. Today with interest, it's about 53 crores. Now, we had only filed execution for asking them to deposit in court because there are RFAs pending, and the LAC court had clearly said, let the money be deposited back, subject to whatever the RFA court decides. The
Now,
money will be
what's the
dispersed.
issue here?
The money has not been deposited, and the execution court says,
Where is the order to deposit money? RFA court ಅಲ್ಲಿ ಹೇಳಿದ್ದೆಲ್ಲಿದೆ?
well, it's not in the RFA court, in the LAC court, after which there were 2 MFAs filed, both were
Confirmed?
confirmed.
Where is it? ಕೊಡಿ.
Manoj, the
First,
LAC
first order of the LAC court.
LAC court, Manoj. Manoj, page number 124 to 125. 124 ಗೆ ಬಂದ್ರೆ
124.
124.
ಹಾ.
Disposal, last paragraph. Disposal of the RFA will take considerable time. Hence, direction is given to SLAO and bank, where the accounts of claimant number 1, 3, and 4, who are R1 to R3 here, have been freezed at the instant of the police, shall be defreezed and the amount shall be deposited before the court at the earliest. Next page. The claimant numbers 1, 3, and 4 deposit amount which have not been freezed together with interest at 9% within 2 months from the date of the order. Failing which they are liable to pay interest at 15% till entire amount is deposited. If SLAO fails to deposit the defreezed amount, under our claimants 1, 3, and 4 fail to deposit the amount which has not been freezed, the claimants can recover the amount from the respondents, respondent being BMRCL and KADB. Now, against this, they filed an MFA before Justice Mudgal's division bench. It was rejected. They filed a review, rejected. They went on SLP, rejected. I had filed another MFA because there were parts of the order where I was disentitled in particular instance. That MFA went in my favor. That has been final now. No SLP filed. Now I go to the execution court asking only for the money to be deposited because my lords KADB did not.
That is rejected.
That is rejected, saying that they are the judgment debtors, they are the judgment holders anta.
Yes, sir.
And R1 to R3 last occasion also they did not appear. They are on wakalat. Today also they are not appearing.
ನೀವೆಲ್ಲ ಯಾರು?
I am for R4 to R7.
They are all the other
Who are
claimants.
the beneficiaries?
R1, now beneficiary.
Which is the account where the amount is lying?
One, we don't know because my lords, the LAC court.
How do we protect you then?
My lords, two points, my lords. LAC court had told KADB to defreeze because about 19 crores was frozen. They asked to defreeze and deposit it into a court. They deposited only about 46 lakhs. MF.
Who appears for the board?
I'm for the R1.
Board.
R1.
R1 ಅಂದ್ರೆ ಯಾರು?
Oh, they are the ones who are to deposit.
Beneficiaries. Yes, sir. ಯಾವಾಗ ಆಗ್ತೀರಾ?
ಒಂದು 2 weeks ಅಲ್ಲಿ ಆಗ್ತೀವಿ ಸರ್.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ಡೆಪಾಸಿಟ್ ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಸೀನಿಯರ್ ಇಲ್ಲ, ಹಾಗಾಗಿ 2 weeks.
ಅವರೇ ಬರ್ಬೇಕಾ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ?
ಇಲ್ಲ ಸರ್, ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು ನಾನು ಮಾಡ್ತೀನಿ.
Illegally ದುಡ್ಡು ತಗೊಂಡ್ಬಿಟ್ಟು ವಾಟ್ ಇಸ್ ದ ಬೋರ್ಡ್ ಡೂಯಿಂಗ್?
They are also not here today.
Account, your account ಯಾವ್ದು freezing or order ಮಾಡ್ಬೋದು, ಎಲ್ಲಿದೆ?
I've got
Accounts
the
ಕೊಡಿ.
accounts here.
Give the account.
The same details were
Well,
provided.
direct
for-
freezing of the account.
This is R1's account, my lords.
ಒಂದು ನಿಮಿಷ. You are judgment debtor.
My lords,
Who are you? Decree holder.
I am the decree holder.
The petitioners, for the petitioner is the decree holder. The proceedings emanate before the LAC court. The LAC court observes that the judgment debtors had illegally taken the compensation amount and directs defreezement of the account by the KIDB, by
KIDB
by
and
the KIDB in order to deposit the amount. The order of the LAC court reads as follows, page 124, 125. This is challenged before the this court in MFA
8171 of 2022.
8171 of 2022, which comes to be dismissed. The dismissal of which was challenged before the apex court, which comes to be dismissed. Therefore, the order passed by the LAC court in LAC 30 of 2022 has become final. The petitioner decree holder files an application before the concerned court directing compliance with the order passed by the LAC court, which had been affirmed not once but twice before this court, even in writ petition 12988 of 2021. The deposit has not come about. The learned senior counsel Harsha Narsappa seeks to place reliance upon, places a memo with regard to the account held by the respondent, respondent number 1.
Other two are minors, my lords.
Respondent number 1. Therefore, the account, therefore the board shall oversee that the account of the account of first respondent be frozen till the next date of hearing and no activity be permitted in the said account till the next, without the leave of the court.
Accounts, my lords. They have given
Accounts ಮಾಡಿ. Yes.
much.
ಹಾಕಿ. Yeah, 6 ವಾರ ಬೇಕಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ 2 weeks ಸಾಕು.
ಸಾಕು, 2 weeks. Objections, if any, by the next date, list on 31st.
Much obliged.
70.
ಅದು
The petition, my lord. Lord, last time it was submitted, the interim order, it's please.
Yes, sir.
Last time it was submitted, my lord. The interim order itself will become the final order, based upon which they had taken 2 days' time, my lords.
Yes, sir.
That produce documents,
ಏನು plaint reject ಮಾಡಕ್ಕೆ?
plaint reject ಮಾಡಿ. Only thing is this, PDA has given an endorsement.
I will hear it. The petitioner, learned counsel of the petitioner submits that the interim order so passed could be the final order, as it is lucid that the plaint should be rejected on the said score. The learned counsel for the respondent would want to make his submissions. In that light, the interim order stands extended till the next date.
Until further orders ಆಗಿದೆ.
Until further, ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Sir,
ಆಗಿದೆ.
in that light, list the matter on
Dot point involved, my lords.
on 14th October. Yes. Next.
71.
It may be taken at 2:30. I'm
Oh,
ready.
ಇದು, yes, sir.
It may be taken at 2:30.
ಅಲ್ಲ 2:30 ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಬೆಂಚ್ ಇದೆ ಅಂತ ಅದಕ್ಕೆ
ಇಲ್ಲ ಸ್ವಾಮಿ ನನಗೆ
Pass over ಅಷ್ಟೇ 2:30. ಅವರೆಲ್ಲ ಹೋಗ್ತಾರೆ? ಇಲ್ದ ನಾಳೆ ಬೆಳಗ್ಗೆ ಹಾಕ್ತೀನಿ.
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಮೇಕ್ ಮೈ ಸಬ್ಮಿಷನ್.
ಬೆಂಚ್ ಇದೆ ಅಂತ ಅನ್ಕೊಂಡು ಅವರು ಇದು ಮಾಡ್ತಾರೆ.
ಯಾವ ಬೆಂಚ್ ಇದೆ ಅಂತ ನನಗೇನು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
Yes.
B group matter 72.
Pre-lunch ಇಷ್ಟೊಂದು ಟೆನ್ಷನ್.
Because on the last occasion, the learned AG was directed to appear and he had made certain submissions. That's what my lord, the government had.
Is my lordship in Delhi today.
ಡೆಲ್ಲಿನ್ ಮಾಡ್ತಾರಾ ಸಬ್ಮಿಷನ್?
ಬಂದಿಲ್ಲ ಅದಕ್ಕೆ.
Idrali, because how they are supposed to be compensated. So it appears, my lord, that they were supposed to have had, my lord, a detailed discussion with the farmers in those villages. It seems some, if your lordships were to see the order dated, 17-9, 19-9 of 2024 and 21-9 passed by this
ಈಗ ಏನ್
honorable court.
ಮಾಡೋದು ಹೇಳಿ?
ಅಲ್ಲ, my lord, this day after tomorrow, my lord, day after tomorrow, the landowners,
ವಾಯ್ಸ್ ಎಲ್ಲ ಕೇಳಿಸ್ತಾ
this, my lord, day after tomorrow, my lord,
ಇಷ್ಟೊಂದು ಟೆನ್ಷನ್
hello, day after tomorrow, the landowners are, my lord, they are having a meeting with the BDA people, my lord. So this ultimately, my lord, if the whole thing works out, then there's nothing like it, my lord. Otherwise, your lordship may have to hear.
whatever, after vacation we'll
Please.
take it. No, that's why I posted it. Huh? We'll fix a date.
Yes,
We'll fix it on 17th October.
please.
And list the matter on 17th October. Interim order of any kind subsisting in any of these petitions shall continue till the next date of hearing.
Oblige.
73.
I represent Mr. Lakshmi Shram.
Covered, covered matter, is it? Which judgment? Covered?
Lakshmi Shram matter. Lakshmi have it.
Covered ಇದ್ರೆ ಹೇಳಿ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ.
ಮತ್ತೆ ಅವ್ರೇನ ಇಟ್ಕೊಂಡು ಏನದು ಮೇಡಮ್? ಕೊಡಿ ಅವ್ರಿಗೆ. Yes. Murugesh.
Not covered. Nagarbovi not.
Huh?
Nagarbovi not covered.
Nagarbovi
is substantial, fully implemented, almost all 90% of
the learned counsel appearing for the petitioner submits that the issue in the list stands completely answered by the judgment rendered with the coordinate bench in so and so. The learned counsel for the BDA would seek to dispute the same. List this matter immediately after vacation.
Hello, ಮಡಿವಾಳದಂತ ಕೇಸು ಇದು ನಾಗರಬಾವಿ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದವರು ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ
ಕಾನ್ಸೆಪ್ಟ್ ಏರಿಯಾ ಮೇಲೆ ಡಿಪೆಂಡ್
ಹೌದು ಈಗ ನಾವು ಡಿಫರೆಂಟ್ ವರ್ಷನ್ ಇಸ್ ಟೇಕನ್ ಇನ್ ಆಲ್ ದ ರಿಟ್ ಅಪೀಲ್ಸ್ ಫೈಲಿಂಗ್ ಎ ರಿವ್ಯೂ that learned single judge relied
just
upon
immediately after vacation. Yes, next.
24.
ಬೇಗ ಕೊಡಿ.
Yes, ಏನಾಗಿಲ್ಲ ರಿಟ್ ಅಪೀಲ್
ರಿಟ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ
ಅಷ್ಟೇ. ಏನಾಗಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ದಿಸ್.
I have a submission to make on the merits. Even otherwise, the scheme according to us is substantially implemented. ಹೇಳಕ್ ಬಿಡಲ್ಲ.
Sir, look into the order of the coordinate bench. Detailed order passed on 25/3/25. ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ.
I'll be able to establish the division bench of this honorable court way back in 1996 had held that the scheme is implemented and substantially implemented. That is what the learned single judge does not take into consideration. Not the order.
Deals with it and thereafter votes with the existing state of affairs that the scheme is not implemented. But if your lordships were to see page number 210 para 71.
ಆಯ್ತು. ಕೇಳೋಣ immediately.
Please, synopsis list of dates.
ಕೊಡಿ ಎಲ್ಲ. We'll post it on 23. Yes.
Along with the list of dates and events and judgments.
Learned counsel for the heard the learned counsel, senior counsel D.R. Ravi Shankar appearing for the petitioner. The learned senior counsel submits that the issue in the list stands completely answered by the judgments appended to the petition. The learned counsel for the respondent would seek to dispute the same and further seeks to place reliance upon plethora of judgments which are now placed along with a memo. All the same is taken on record list on 23rd at 4 PM. Yes, next.
Please.
Intermodal subsisting will continue to the next date. Next.
Please.
75.
Yes, sir.
I am for the
Vacating stay ಹಾಕಿರೋದು ನೀವಾ?
petitioner in the
ಅಲ್ಲ
connected
vacating
part-
stay ಹಾಕಿರೋದು ನೀವಾ?
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಓ ಇವ್ರದ್ರಲ್ಲಿ ಹೇಳಿ
ನಮ್ಮಲ್ಲಿ
ಸರ್.
ಹಾಕಿದ್ದಾರೆ. Matter to be heard on merits. And in the meanwhile, we are also exploring the possibility of an amicable settlement. Of course, my friend is disputing, but it's a fact that.
What's the matter? Injunction, other lane, yes.
There is an agreement of sale. There is an agreement of sale.
It will take it at 2:30. Or immediately after the bench.
It may be taken up after vacation.
Will, after Amal ಮಾಡೋಣ.
ಆಗ್ಬೋದು.
Come back. ಅವರಿಲ್ಲ. $75. FR ಪೆಂಡಿಂಗಾ? ಆಯ್ತು ಹೋಗುತ್ತಾಳೆ ನೋಡ. ಎಷ್ಟು 1000 ತಗೊಳಕ್ಕಾಗಲ್ಲ. ಎಸ್ move the vacation bench, madam. When was it attached? When was it attached? Yesterday. Give it. Yes.
My lord, I'm moving for a
86 on dictating for judgment.
ಯಾವುದು ಸರ್?
86 are the land acquisition damages, either on a land or total compensation 15%.
Oh, dictating orders. We'll see. Yes. Other that Singh.
Balwant Singh.
Balwant Singh.
Now I have got one more matter, it is in my favor.
ನಿಮ್ ಬಲವಂತ್ ಸಿಂಗ್ ಅಂತ ಬಲವಂತ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ?
ಹಂಗೇನಿಲ್ಲ.
ಇಲ್ವಾ? ಸರಿ.
ನಡೆಯುತ್ತೋ ಇಲ್ವಾ ಕೇಳ್ಕೊಂಡು. Abundant caution, ಮತ್ ಬರ್ಬೇಕೋ ಬೇಡವೋ?
ಅದು ಬೆಂಚ್ ಇದೆ, ಬೆಂಚ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತೀನಿ. Yes.
My lord, this is.
Maybe 4 o'clock ಆಗ್ಬೋದು. If you're prepared to wait, dictating, let me see what's possible or not.
My lord, this is.
ಯಾವ್ದು 98? ಯಾವ್ದು 98? ಅದೆಲ್ಲ ಆಮೇಲೆ ಬರೋದು. ಈಗ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಫಾರ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಪಸ್ ಪೋಸ್ಟೆಡ್. ಏನ್ ಹಿಯರಿಂಗ್ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗೋದು. ಮತ್ತೆ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ ಇವತ್ತು. ಅವ್ರು ರಿಸರ್ವ್ ಆಗಿತ್ತು ಆಲ್ರೆಡಿ, ಮತ್ತೆ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ. ಹಿಯರಿಂಗ್ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ. ಕೊಡಿ ಆಯ್ತು ಕೊಡಿ. 84 post the matter before the bench having appropriate roster. The learned counsel for the petitioner submits that there is grave urgency. What is sought for is modification of an order passed by the coordinate bench. Therefore, the registry is directed to place the matter before the bench which had passed the order.
We have 2 tax matters being filed on behalf of a temple, my lord.
You told me ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಈಗ?
My lord, the one temple, it has already been attached. Bank account.
Temple attachment.
A temple bank account is attached by the.
Bank account. Temple attachment.
No, my lord, temple bank account is attached, and there's another one wherein demand notice is issued and there's apprehension of attachment, my lord. We've
You
already
moved them. I
received
took it in the morning.
Date.
ಅಲ್ಲ ನಾಳೆ ಕೇಳಿದ್ರಾ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಕೇಳಿದ್ರಾ?
Maybe taken up tomorrow, my lord.
ಆಯ್ತು ಕೊಟ್ಟಿರಿ.
I wouldn't move if there's not.
Give it, we'll see. Fresh matter. Pending ಅಲ್ಲ ಬೇಡ.
ಇಲ್ಲ fresh, my lord.
Apologies to make a mention, my lords, right now. Serial number 72, list number 2, my lords. If it can be posted after
Tax
vacation.
matter.
No, it is GST, my lords. It is not
No
faceless.
problem. It will come after vacation. Interim order iddre it will continue.
Yes, my lords. If it can be posted, if a dates may kindly be given.
I don't know. If I continue, no problem. Otherwise, we'll see. Yes. Tax, I'm doubtful. Otherwise, others okay. That's why I'm giving dates.
My lord, may I please make a mention, my lord?
71, it is delinked, madam. Don't worry.
No, not 71, my lord. My serial number 79 is my number. I wrongly stated
79, all right.
71. Sorry, my lord. Please restore the file 71 and
You
79.
don't worry, madam. Why are you so
17
much worried? Don't worry. Yes.
Sorry, my lord. 79.
Yes.
Interim stay also may be extended.
Yes.
My lord, there is a threat of demolition of building by BD, my lords. Yesterday it was
ಬೆಳಗ್ಗೆ
ordered.
move ಮಾಡಿದ್ರಿ?
ಮಾಡಿಲ್ಲ, my lords.
ಮಾಡಿಲ್ಲ ಕೊಡಿ. End of the list third.
Much obliged.
We'll see.
Serial
I'll finish the bench and come, maybe four.
number 19 ಬಲ್ಲ.
Huh?
ಅಲ್ಲ serial number 19 ಅದರಲ್ಲಿ R1 ಗೆ ನಾವು ಇದೀವಿ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟಡಿ ಇದೆ R1
19 or 9?
19 ಮೇಲೆ
ಏನಾಯ್ತು?
ಅದು ಅಡ್ಜಾರ್ನ್ ಟು ದಿ R1 R2 and R3 ಗೆ PF ಅಂತ ಹೇಳಿ ಅಡ್ಜಾರ್ನ್ ಆಗಿದೆ. I will ready to behalf of R1 R2 ಗೂ ನಾವು ಅಪಿಯರೆನ್ಸ್.
What's up?
ಅಡ್ಜಾರ್ನ್ ಟು ದಿ R1 and R2 ಏನಾಗಿದೆ ಅಂದ್ರೆ R1 only for the
ಮೇಡಮ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ಸ್ ವೇಟ್ ಮಾಡ್ಬೇಕು.
R1, 2 and 3 PF
for